So in today's session, we will be discussing entire polity, specific topics that have been picked out, and through this series, you will be able to revise the entire subject, especially the important parts, the most important parts of the subject, what the repetitive pattern of UPSC is. And that pattern, I'm sure, is going to be the only thing that you need to boost your score right around the prelims. That any law that has been formulated by government, by parliament, by anybody, and if it violates any fundamental right, if it encroaches any fundamental right, counters any fundamental right, whatever it is doing, violates, encroaches, counters, all kinds of situations, in any kind of situation, if it is derogatory to our fundamental rights and harming our people, it will be unconstitutional immediately. Unconstitutional, void, and will not be implemented. Any law. The question is why? You see, who is the guarantor of Constitution? Who is the guarantor of Constitution? Who is the ultimate interpreter of Constitution? Supreme Court. If Supreme Court is coming up with something, naturally the constitutionality of that is already checked. How can you challenge that? After examining everybody, it is not judiciary that prevails. It is not the power of judiciary. It is the supremacy of Constitution. Only what Constitution says will prevail. That is when court came up with right to live with dignity. What kind of life do we want to have? Right to live with dignity. Right? And from here the debate came forward that if you have the right to live with dignity, you have the right to die with dignity as well. Then why not allow Sadhara, euthanasia, etc.? Here is that there are certain directives outside of part 4. That is UPSC's favorite question. Yeah? Which are the directives outside of part 4? A favorite topic of UPSC, a favorite topic of UPSC. Once again, please remember, there are certain limitations. What are those limitations? The limitations are, number 1, they cannot pardon punishments given by court-martial. In certain scenarios, Rajya Sabha has special powers. Special powers. And in some cases, they have no power. Hello everyone, welcome back to your favorite channel, Drishti IAS, and this is Divya Kawatra, your educator, and we meet today for our Score Booster series for Prelims 2026. I hope you all are doing good, and we are beginning a series, Part Polity, for you today. And in this series, you will be witnessing all the important topics that have been picked out by our team, specially for you, amongst the past 10 years PYQs, the topics that have been very important, that have been repetitively asked, that have been constantly in the news, and that have been repetitively been favorite of UPSC, right? These are the specific topics that have been picked up for you, especially in the Score Booster series brought to you by the Drishti family. So in today's session, we will be discussing entire polity, specific topics that have been picked out. And through this series, you will be able to revise the entire subject, especially the important parts, the most important parts of the subject, while at the same time, you will be revising the overall political structure of India. Yes? Through this series, you will be able to cover up the most important topics, and not just that, you will be able to witness what the repetitive pattern of UPSC is. Right? And that pattern, I'm sure, is going to be the only thing that you need to boost your score right around the prelims. Yes? So are you all ready to join me in this session and to begin this class with zest and zeal, and let's cover polity like we've done never before and make sure that this time we get a perfect score. Yes? Are you all ready to join me in that? So let's continue and let's begin with this part. We will be taking topic by topic analysis, and in that topic by topic analysis, you will be able to witness how a particular topic can be summed up and what are the key factors that have been very significant in pulling out questions, in giving questions repetitively to UPSC. All right? Exactly. So this series is going to be very helpful for you. Sit tight and keep watching till the end, because every single topic has a surprise packet for you, has certain facts for you that are definitely going to give you a question. Yeah? Shall we continue then? Are you all ready? Yes? Okay, so we start with our first topic, and one by one we will be going through all of it. This is our score booster series. Let me remind you, each subject will be covered here one by one, and today we are covering polity. All right, let's begin. Let's start with our first topic, our very first topic, that is preamble. Now, before we go for the preamble, I have a quotation here for you, a very beautiful quotation that I myself heard long time ago and has stayed with me all these years. Yes, the quotation is that you and only you can be the author of your own epic. Right? What does it say? It is a very beautiful quote that says your dreams are the epics. Anything that you dream of, the entire dream is an epic. That epic whose author is you. You are responsible for writing that dream. You are responsible for writing that life. So let's write a very good story this time. Yes? Exactly. All right. So on that note, let's begin our first topic, that is preamble. And in preamble, the very basic thing that we know about preamble, what is it? The very basic thing. What is a preamble? Like just now, before starting the session, I gave you an introduction about the session, what the session is about, how you are supposed to handle that, how you are supposed to tackle that, right? I gave you that. This was what? A preface to the lecture, a preface to the entire lecture that is going to happen right now, right? Preamble plays the same role. Preamble is a preface to the Constitution. What is it? It is a preface to the Constitution. Like, what kind of preface are we looking at? It is a preface that tells us what Constitution is really about. Yeah? What Constitution is really about. What is it doing? What kind of India is it establishing? That is what we are trying to figure out through this preamble. Now, why preamble? We already have a constitution. Yes? Why do we need a preamble to tell us what constitution is saying? Why can't we figure it out from constitution itself? Right? So what happens is, see, the constitution is one of the world's most lengthiest written constitution. You know that, right? So our constitution makers also understood the fact that this is not something that is going to happen either way. That every citizen goes about and reads the constitution. That is not going to happen. And if that is not going to happen, we have to make sure that we transfer the ideas, at least the very basic ideas that our constitution has, that need to be transferred to the people. People need to understand what kind of constitution we have created, because apparently our constitution gains power from people. Where does it gain power from? We gain power from people, right? And if we are taking power from people, we definitely need to give that back, right? So in that scenario, people need to understand what kind of constitution we've made, what kind of India we are trying to make, what kind of rights these citizens are going to have, what is our oath as such, what kind of India are the leaders coming together to make. To understand that, we need to look at our preamble, because it gives a very clear picture, right? A very clear picture as to what this entails, what the constitution holds, what kind of India we are going to build, right? It gives all these details very clearly. Is that true? Yes, exactly. So that is what preamble is for us. However, do remember that preamble was not added in the beginning, but added at the end of the entire constitution, right? It was added at last after the entire constitution was made, because we wanted to make sure that the entire idea of constitution is summarized here and nothing is left out, right? We wanted to make sure that nothing was left out, and that's why we came up with this. Is that clear? Yes. Yes, exactly. Now that is what preamble entails. And what kind of preamble do we have? This is our preamble. I'll give you a second to just read it through, because I want you to remember this. I want you to learn preamble word to word, because this is going to give you answers. This is going to give you answers. This has so many elements that many of the questions, even when they're not directly from the topic of preamble, can still be answered from here. This is a very powerful tool to have if you have memorized the entire preamble. Just give it a read. I'm giving you 1 minute. Just give it a read and see whether you remember it or not, whether you know what this is or not. Yeah? Yeah, just give it a read and see how do you feel. Like, do you remember any parts of it? Is it any better for you? Yeah? So what we are trying to do here is, we're trying to understand what preamble is telling us. Okay, preamble is saying, we the people of India. Who is talking? We the people of India. Okay, first thing. Having solemnly resolved to constitute India into, what kind of India do we want to make? Sovereign, socialist, secular, democratic, and republic. What? Sovereign, socialist, secular, democratic, republic. How many elements are there? 5 elements are there. Sovereign, socialist, secular, democratic, republic. Is that clear? Yeah? How many elements? 5. Remember the sequence. Remember the sequence. Yes, there's a question there. Remember the sequence. Sovereign, socialist, secular, democratic, republic. You have to remember that. Okay? Please remember that. And after that, to secure to all its citizens, what? Number 1, justice. What kind of justice preamble wants to give? Social, economic, and political, naturally. Then liberty of thought, expression, belief, faith, and worship. What kind of liberty do we want to give? Thought, expression, belief, faith, and worship. Again, 5. Thought, expression, belief, faith, and worship. There's a symmetry. Yes, look at that. There's a symmetry. Thought, expression, belief, faith, and worship. Very nice. Equality of status and of opportunity, and promoting among them all fraternity, assuring dignity of individual, and unity and integrity of the nation. Yeah, this is added. This was added, right? This was added. This was added. We've added all these later on. And in our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Yeah? Exactly. On which day? 26th of November. Adopt, enact, and give to ourselves this Constitution. People of India are saying this. Who is saying this? The people of India. You and me, we are saying this. So number 1 thing this preamble tells us is, where does Constitution get its power from? Where does it get its power from? The people of India. The source of power here is the people of India. This is the first element we get from here. What is it? The source of power. Yeah. What kind of India do we need to make? Sovereign, socialist, secular, democratic, republic. This is another question for you. What kind of rights citizens get? Justice, liberty, equality, fraternity. Yes. What is their duty then? To maintain fraternity. These are the rights. These are the rights. And then this is the duty. Yes, this is the duty. You maintain fraternity, you maintain unity, you maintain integrity of the nation. Is that clear? While nation is giving us so much, this is the least we could do, right? So it is entailing everything, the kind of India we want, what we'll do for the citizens, what citizens will do for us, and how we'll work together like this. We are adopting this Constitution by enacting this Constitution, by giving to ourselves this Constitution, and then by following this Constitution, right? That is how we will be able to actually adopt a better coordination. Yeah, exactly. This is our preamble. It gives us a source of authority. How do we get a source of authority? From we, the people of India. Yeah. How do we get the nature of Indian state? Sovereign, socialist, secular, democratic, republic. That is the nature of Indian state. Next, we have objectives of the Constitution. What is the objective? To give to citizens. To give to citizens what? What do we want to give? Justice, equality, liberty, fraternity. justice, equality, and liberty. Right? Then what are citizens going to do? They are going to promote fraternity, unity, and integrity. Yes? Is that true? Exactly. Date of adoption, 26th of November, 1949. However, did we enact entire constitution on this day? No. Did we? You remember that, right? No, we did not enact entire constitution on this day, right? Exactly. When did we enact the entire constitution? On 26th of January. Yes, very good. Here only necessary articles were enacted. Only necessary articles were enacted. Articles from 1 to 4 were also included in 26th January, not included on 26th of November, right? Yeah. So we did adopt the constitution, but we did not enact entire constitution. We enacted the entire constitution on 26th of January. Yes, is that clear? Very nice, very nice, very nice. Okay. So this is the first aspect. I hope it is clear up till here. Yes, the very first aspect of preamble that we need to know. Yes. Okay. So this is basically entire philosophy of the constitution. Entire philosophy of the constitution. By 42nd amendment, what did we add? We just marked here sovereign, secular, socialist, and integrity. Secular, socialist, and integrity. 42nd Constitutional Amendment 1976. Very simple trick, 1976. We have two important constitutional amendments, 42nd and 44th. Yes, 42nd and 44th. Most people get confused which was done when. So very simple trick used since years and years and years. 1978, 6 and 8. Very simple to remember. Yeah. So 42nd Amendment 1976 gave us certain changes. Okay, what was the change? That by 42nd Amendment we added 3 more words to the preamble. What words did we add? Socialist, secular, and integrity. And integrity. Actually, technically this is 4 words. Technically this is 4 words. One is the preposition, that is and. Because it was only unity, so we added and integrity. Okay, remember that? Socialist, secular, and integrity, these were added by 42nd Amendment. Where do we get its inspiration from? We get the inspiration from objectives resolution. Inspiration comes from objective resolution. Yes, where does the inspiration come from? Objective resolution, right? Objective resolution that was written by Pandit Jawaharlal Nehru. Pandit Jawaharlal Nehru. Is that clear? Yes. The idea, however, has come from American Constitution. Idea has come from American Constitution. The content of preamble is inspired from objective resolution, but the idea is taken from American Constitution. Please remember that. Idea is taken from American Constitution. Clear? Is that clear? Yes? Okay. So this is what preamble entails. Why is it so important? The preamble is so important because it embodies the entire system, it embodies the entire spirit of the Constitution. It talks about entirely what Constitution expects of us. What kind of Constitution do we have? What kind of developments are there? Everything is entailed here. It unravels the minds of constitutional forefathers, of course, the leaders who have framed the Constitution play an important role there. It contains basic principles which Constitution aspires to fulfill, yes, because it tells us what kind of country we want to make, what kind of country India needs to be. Yeah, so it entails future perspective as well, gives us future perspective as well, does it not? Yes, exactly. Do you agree there? Does it give us a future perspective? Yes. Right? Exactly. So this is our preamble. This is our preamble. Is that clear? Exactly. Now different ideals are here that we have taken from different areas: social justice, economic justice, political justice, right? Exactly. However, there are some important cases that are related to preamble. There were cases because since there was a question that there is a whole constitution, then there is preamble. So whether that preamble is a part of the constitution or not. Number one question. Second, whether we can amend it or not. It was amended in 42nd amendment, but then that raised the question. If it is not a part of the constitution, how are we amending it? Tricky, right? First of all, they want to know whether it is a part or not. Then they're saying whether we can amend it or not. The thing is, if it is not a part, how will you amend it? What are you amending then? Right? So it has to be a part. But if it is a part, then is it so easy to amend it? Wouldn't that shake the entire spirit of constitution? Because apparently, we just now established that preamble embodies the spirit of constitution, right? So wouldn't that shake it? So can we amend it or not? These two questions needed answers. For that came cases. Okay, so we had a certain case laws where number one is Berubari Union of 1960, where it was declared by the court that preamble is not a part of the, what did they say? Not a part of constitution. And if it is not a part of constitution, naturally it cannot be amended. True? Preamble is not a part of the constitution, so naturally it cannot be amended. This was said in Berubari Union case. Okay, but then 42nd amendment has happened, so what to do about that? So in 1973, in the Keshwan and Bharti case, again court says that preamble is the part and can be amended. Preamble is the part of constitution and can be amended. Okay, so if it is a part of the constitution and it can be amended, doesn't that mean if we remove the democratic word from preamble, if we amend the preamble and some government is successful in removing the democratic term, does that mean India won't be a democracy anymore? How will that go? Right? So this amendment was again in question. So this time in LIC of India case 1995, it was again reiterated that preamble is a part. Preamble is a part of the constitution. However, by then we have also developed the case of basic structure, right? The case of basic structure. So the already existing parts of preamble, you can add more, but you cannot change what is already there. Already existing part is a basic structure. You can add but cannot subtract, right? You cannot change what is already there. You can add something new, you can make some amendments, yes, but then again, you cannot change the basic structure, and democracy obviously is one of the basic structures of Indian Constitution and India, right? So this way the question was solved. It can be amended, but basic structure won't be amended, and it is a part of the Constitution. So right now, what is the condition? Preamble is a part of the Constitution. It can be amended, but not the basic structure. Clear? Yes? Clear up till here? Do we understand the kind of questions that can be framed from here? The statements that can come out of here? We've clarified all that. Please remember, different cases saying different things, but right now the present condition is that it is a part of the Constitution, it can be amended, and we cannot amend basic structure. Clear? Yes? All right. So this is our topic of preamble. This is our topic of preamble. Let's solve a few questions. What do you say? Yes? Let's solve a few questions. Yeah? Ready? All right. Read the question and tell me the answer quickly. So the question number one is that what was the exact constitutional status of India on 26th January 1950? a democratic republic, a sovereign democratic republic, a sovereign secular democratic republic, and a sovereign socialist secular democratic republic. Wow, quite a tongue twister, right? Okay, answer quickly. This is the PYQ from 2021 paper. Okay, just to give you an idea of what kind of questions can be asked. That's it. Very nice, very nice, very nice. Okay, so what did we have? We obviously added the socialist and secular part later on. So naturally we didn't have that. Sovereign Democratic Republic. That is it. As of 26 January 1950. Next question. Next question. Give it your best shot. Come on. Give it your best shot. Which one of the following objectives is not embodied in the preamble to the Constitution of India? 2017 question. Liberty of thought, economic liberty, liberty of expression, liberty of belief. Yeah. Give me an answer quickly. Give me an answer quickly. Yes. Very nice, very nice, very nice. So the answer is B, that is economic liberty. Yes. We don't talk about economic liberty. Clear? Yes. That was our first topic of preamble. We have catered to all the important points. Yes. Okay. We'll be pacing it up a little bit. We'll pace up a little bit. That is it about preamble topic. Shall we move forward? Yes. Clear? Okay. Moving forward, we have our next topic, that is fundamental rights. Now, not the entire fundamental rights as promised. We will be picking topics that are coming from the trends of PYQs. The trends of PYQs, the most important part of the most important topics that are trending. So only those will be discussed, not the entire topic. Please remember that. Okay. So we are starting with fundamental rights. What are fundamental rights? Fundamental rights, the basic rights given to the Indian citizens or some outsiders as well, foreigners as well. Basic rights that are necessary for us to, especially as a citizen, for us to, give up our rights to a particular state in return for protection, in return for security, in return for life, right? We do that. Now, these rights, as embodied in the Constitution, Part 3, Article 12 to 35. Yeah? Part 3, Article 12 to 35. That is where fundamental rights are given in our Constitution. We have 6 kinds of rights. Yes? Number 1, right to equality. Then right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Constitutional remedies is what we are going to discuss in detail. Other than that, we will also discuss particular articles like 19 and 21, right, that have special effect during emergencies, the type of area where UPSC finds questions. Okay, so let's begin. First of all, we are talking about the definition of state. We're talking about Article 12 and 13. Okay, we're talking about Article 12 and 13 first of all, right? If you notice here, fundamental rights begin from Article 14. Before that, we have 12 and 13. And amidst those 12 and 13 articles, we have certain articles or we have certain provisions to discuss. Okay. Now, these provisions basically bring forward, first of all, the definition of state, saying that what does state entail? When we say that state is supposed to protect your rights, who is state? Who is state? Is that a person, a body, an embodiment? Will take legislature, executive, judiciary all together, or who? Is there any particular source? So state has been defined by Constitution. Like, which state are we talking about? Okay. Now, to define that state, what have we said? To define that state, what have we said? We've said that this state includes all the government and Parliament of India. Like government and parliament, right? India, state, local authorities, right? This government is on all levels, India level, state level, local level, on all levels, we are talking about the state government. and other authorities that are here in the Indian territory. The entire Indian territory is covered here, and in the entire Indian territory, all the offices that we have, any kind of authorities, government authorities that are present here, that are being governed by Government of India. Yeah, any which way, directly, indirectly, any which way, anybody who is being governed by Government of India automatically becomes a part of our state. Yeah, they become a part of our definition of state. Is that clear? Yes, that is the state we are talking about. That is the state we are talking about. Is that clear? Yes. So this is what Article 12 tells us. What is state? What is state? Yeah. Any agency, any organization, etc., everything will be included here. Yeah. Article 13, however, defines law. Okay. 12 defines state, 13 defines law. What kind of law? Article 13 defines law inconsistent with, derogation of fundamental rights. Clear? Why? Because they say that any law that has been framed and actually counters the fundamental right will be unconstitutional and void. Immediately unconstitutional and void. That is what Article 13 says. What does they say? That any law that has been formulated by government, by parliament, by anybody, and if it violates any fundamental right, if it encroaches any fundamental right, counters any fundamental right, whatever it is doing, violates, encroaches, counters, all kinds of situations, in any kind of situation, if it is derogatory to our fundamental rights and harming our people, it will be unconstitutional immediately. Unconstitutional, void, and will not be implemented. Any law, right? No exceptions. Any law that is saying that we will counter fundamental rights, gone. Right? And if there is anything, any law or action that is actually countering, people have the right to approach directly Supreme Court or High Court, not only Supreme Court, or High Court under Article 32 to place a writ, that is working for protection of fundamental rights. Is that clear? Yes, for the protection of fundamental rights. Clear? Very clear? Yes, exactly. This is Article 13 for you, the definition of law. Definition of law. Clear? Yes. You cannot take away fundamental rights. You cannot abridge fundamental rights. There should be nothing. Any law that is made to counter this or is in controversy with the fundamental rights will be declared void. Simple. Article 13. Clear? Absolutely clear? All right. Let's move forward. Let's move forward and see what source of law is. Okay. What kind of law, what source of law are we talking about? Right? So first of all, we have permanent laws. Permanent laws that are actually enacted by Parliament. Yeah. Any permanent law that is enacted by the Parliament will be included here. Yes. Temporary laws like ordinances will also be included here. Temporary laws like ordinances are also included. Okay. Yeah. Not just permanent, temporary like ordinances can be included. Please remember that for prelims. Mostly we think that, okay, it should only be for permanent laws. Why bother with temporary laws? No, temporary are also. Statutory instruments are also covered here. Statutory instruments. Okay. We also cover statutory instruments here. Please remember that. We also cover statutory instruments. Non-legislative sources also. What are non-legislative sources of law? Tell me quickly, non-legislative sources of law. What kind of non-legislative sources of law can you think of? Huh? Like customs and usage. Okay, like customs and usage, all these are also covered under this scenario. Is that clear? Yes? Do you understand that? Non-legislative sources also, any law set up without any legislation, right? Constitutional amendments are here. They can also be challenged if they violate fundamental rights, right? Yeah. Constitutional amendments can also be challenged. Please remember that. They can also be challenged. Why? If they violate fundamental rights. Is that clear? If they violate fundamental rights. If they are in violation of fundamental rights, especially the ones that are a part of basic structure, right? For others, we can still consider that maybe fundamental right needs an amendment, right? But basic structure, okay, that cannot be changed. If we say that, okay, constitutional amendment cannot be made on fundamental rights, that means fundamental rights cannot be changed. But we change that. From time to time, we change that. But it should not counter basic structure. Clear? Is that clear? Yes? All right. Very nice. Very nice. Very nice. It does not include, what does it not include now? It has included everything and it seems like nothing else is left. But there are things that it does not include. It does not include what? Remember that it does not include laws that are declared by court or made by Supreme Court under 142. Any law that Supreme Court is coming up with. This is about Parliament. It does not include laws coming from Supreme Court. Why? The question is why. To understand, you cannot cram everything, right? You need to understand why this is happening. What we are saying is it does not include laws by Supreme Court under Article 142. Yeah, that's what we are saying. The question is why. You see, who is the guarantor of Constitution? Who is the guarantor of Constitution? Who is the ultimate interpreter of Constitution? Supreme Court. If Supreme Court is coming up with something, naturally the constitutionality of that is already checked. How can you challenge that? Because even if you challenge, whom will you go to? Supreme Court. Who brought the law? Supreme Court. What's the use, right? So that's why they are not included here. Okay, because ultimately the constitutionality has to be checked by Supreme Court, and if Supreme Court is coming up with the law, naturally they have checked the constitutionality of it, right? So it can be allowed. That's why it does not include laws by Supreme Court. Is that clear? Do you understand the reason behind this? Now you don't have to ratify, right? You don't have to cram it up. You know why this is happening, why this has been excluded. Clear? Yes? Perfect? All right. Amazing, amazing. Let's move forward. Let's move forward and come to the concept of judicial review. Okay. We have another concept specifically, that is judicial review. What is judicial review? What do you think is judicial review? Just take a minute, wire up that amazing intelligent brain of yours and come up with an answer. What do you think is judicial review? 90% of us just think that judicial review is when court goes back, rereads its decision and comes back with a new decision, right? Rechecking their old decision, that is what we consider as judicial review, right? 90% of us limit it there. It is not wrong, it is right, but that is not the extent of it. We don't have to limit it there. That's the problem, okay? Take a look what is happening. In judicial review, what do we say? What is judicial review? It is actually the power of Supreme Court and High Court to review and determine. What do we say? The power of, what is it? The power of Supreme Court and High Court to determine the constitutionality of legislative or executive actions. Legislative or executive actions. Yeah. Supreme Court is not just addressing to its own decisions. Supreme Court is also addressing to legislature and executive's decisions. They're also checking whether their decisions, whether their aspects are constitutional or not. Do you understand that? First thing they're doing. What are they doing? They will check. Legislature has brought a law. Okay, let's see whether it is constitutional or not. Executive has done something. Let's see whether it is constitutional or not. They are taking it upon them to review that. To review and check whether they are constitutional or not. Do you understand the first aspect? Yes? Yes? Very good. Very good. Now, second aspect. What are we doing? In the second thing, judiciary can examine its own actions also. Right? In the second power, it can examine its own decisions also. Under judicial review, they can examine their own decisions as well. Right? Yeah. So they will examine actions of legislature, executive, administrative, everybody, but they can examine their own actions as well. And yet what prevails is constitution, not judiciary, constitution. After examining everybody, it is not judiciary that prevails. It is not the power of judiciary. It is the supremacy of constitution. Only what constitution says will prevail. You understand that? Even though judiciary has been given the right to do this, they cannot actually have absolute power. What will happen here? They will have what? A power to actually implement constitution. Actually make sure constitution is upheld, not their own power. Clear? You understand that? Yes? Okay. Just to make sure basic structure is not getting disturbed. Why? To make sure the basic structure of the constitution is not getting disturbed. Clear? That is our purpose. That is our purpose. Is that clear? Yes? Exactly. Now within this, the whole judicial review power, court of record, as they also act as a court of record, right? And they also act as recalling. They do all that. But amidst that comes two other things, that is equality before law and equal protection of law. A concept of equality before law and equal protection of law. Now these two are interchangeably used. People get confused generally what equality before law means and what equal protection of law means. Okay. So we are going to understand the difference between the two. Judicial review is clear, right? We are moving on to the next article. I hope judicial review is clear. Yes? Is that clear? Equality before law and equal protection of law. Clear? Okay. Let's talk about this. What are they saying? Article 14 says that state shall not deny any person any of these things. State is supposed to give this. Yeah? Equality before law or equal protection of law. Okay. How so? Now, the amazing thing is this is applicable on both citizens and foreigners. So this is quite a serious thing. Yeah. For citizens, we can still say, okay, we'll see that. But for foreigners, we'll work very hard. Right. So here, the article is actually applicable on both citizens and foreigners. So here, what we are trying is, we will give them equal protection of law. But before that, we need equality before law. What is the difference? Try to understand. So, we're talking about equality before law. What is happening? See, you need to make sure that everybody is equal before law. How so? You remember that statue of law, eyes tied, hanging balance. You remember that? Yeah. Why are the eyes tied? Because in the law, in the eyes of law, everybody is equal. Like this, everybody is equal. No differences, right? They don't see whether you're black or white. Like earlier there was a difference between black or white, not now, thankfully. But they don't see which caste you come from, how you look, how tall you are. Apparently tall people have some unfair advantage in life. Right? So they don't see any of that. Why? Because they are trying to say that law is same for everybody. Crime is a crime. Right? Now, the thing is, if everybody who is, being treated equal before the law, when they approach the law, will law also treat them equally? In return, will they turn the favor? Because when you are treating everybody equally before the law, that anybody who is committing a crime under same circumstances should be treated similarly. Simple, right? Equal subjection. Like if we are making a law, we say that murder is a crime, right? We said that murder is a crime. Now it is not like murder is a crime for rich people and it is not a crime for poor people, right? Murder is a crime for tall people, but it is not a crime for short people. Then we cannot do that, right? Murder is a crime means murder is a crime. For everybody it is a crime. Is it not? Yes. So the law is same for everybody regardless of where you are. That is what equality before law means. Is that clear? Yes? Exactly. Now another concept comes, equal protection of law. What is equal protection of law? They said that, okay, you have given us equality before law, that whatever law you make, everybody will have to follow that, regardless of their identities. Yeah? Equal protection says circumstances matter, right? Equal protection is important because this talks about circumstances. If murder is a crime, but you did a murder in self-defense, is that still considered a murder? No. So what they're saying is circumstances matter, and if circumstances matter, you have to make sure that you take them into account. That's why equal protection of law says similar circumstances lead to similar application of law. Okay, not always, right? If you are making a law that you have to pay 30% tax to the government. If a man is only earning 100 rupees per day, you take 30 rupees from the man, what is left? Right? So not everybody will be able to pay 30% tax. You have to make discriminations. You say these people will pay 10%, then 20, then 30. You make those divisions. Why? Because not everybody has similar circumstances. How can you make one law for them? It is not one shoe fits all, right? Everybody is living different circumstances. You have to take them into consideration. That is how equal protection of law can be given. Is that clear? Yes. Yes. That is equal protection of law. Similar application of same laws for people who are similarly situated. Here you can say similar application of law will take place. Is that clear? Yeah. I've developed a chart for you here. This will help you gain a better insight on this. Okay. So what is happening is equality before law means law should be enforced and administered equally. Equal protection of law means there's this definition that all persons in similar circumstances have equal rights and liabilities. Similar circumstances being the key word here, right? Equality before law we took from British origin, equal protection of law we took from American origin, right? Equality before law is a negative concept. Why negative? We are subjecting everybody to ordinary law, regardless of who they are, regardless of what their circumstances are, right? But equal protection of law is considered as a more positive aspect because it is bringing the necessary social and economic changes. Yes? This is similar treatment, not same treatment. Similar treatment. Clear? Yeah. Okay. This was our concept of, equality before law and equal protection of law. Is that clear? Yes, absolutely clear. Any doubts or queries? No? Let's move forward. Next, we are talking about rule of law. What are we talking about? Rule of law. Do we have rule of law in India? What do you think? Do we have rule of law in India? Yes? Do we have rule of law in India? Yes, yes, yes. Okay. In what aspect? Like, give me an example. What makes you think India has rule of law? Any example, like this incident, this provision, this rule, this law, something that tells you that India has rule of law. Anything that comes to your mind. Think about it. Anything that comes to your mind that says India has rule of law. Okay. So this concept is given by A.V. Dicey. Who gave this concept? According to A.V. Dicey, we have 3 elements of rule of law. Okay, there are 3 elements to rule of law. What are the 3 elements? Number 1, no arbitrary power. Okay, number 1 is no arbitrary power. Second is equality before the law. Equality before the law. Third one is individual rights. Okay, being a source of individual rights. If you have these 3 things, you have rule of law. If you have these 3 things, you have rule of law. Right? That means no arbitrary power. What is arbitrary power, first of all? How would we define that? Let's see this. No arbitrary power means until anybody violates law. Until anybody violates law, they cannot be punished. Classic example for this is cybercrime. Okay. There was a time a large-scale cybercrime was conducted in India for the first time. What happened was, it was around 2006, I guess, a cybercrime was conducted in India on government platforms. Cybercrime happened, hacking happened, and with that hacking, a lot of fund was transferred. Whole chaos. This was first incident for India. Since it had never happened before, we never made a law for it. We never made a law for it. We never illegalized it. The hackers proudly came forward to say, we did it. Do whatever you can. Because there was no law to punish them, they were not punished. Was it a crime? Do you feel this is a crime? Yes. But since we did not have a law back then regarding this crime, they were not punished. They couldn't be punished. Retrospective laws, not possible, right? So they couldn't be punished. That's the beauty of it. Anybody who breaks the law will be punished. Other than that, nobody can be punished. Because there was no law, no punishment, right? This is that nobody has arbitrary power like the king. Like I have said, you should be sentenced to death, so you should be sentenced to death. Right? Proof and everything go haywire. No. If you break the law, you're punished. If not, no punishment. Simple. There is nobody who can say, because I am saying you should be punished. No. No, it doesn't work like that. Clear? Yeah? Equality before law, we already discussed. Source of individual rights, fundamental rights. We have individual rights. Yeah? So do we fulfill all 3 conditions? First 2 are still applicable, but third is not applicable, right? Yeah. Because for source of rights, we have fundamental rights, but Constitution acts as a source. Constitution is the source, not the law. Constitution is the source, right? Yeah, in India, Constitution is the source of individual rights. Yeah. Here, they require law to be the source. No. We have Constitution. So, third situation is not exactly applicable in India. but still we can say we have partially rule of law. Yes, we can still say that we have partially rule of law. Clear? Yeah, that is rule of law for you, as defined in the words of A.V. Dicey as well. Clear? Sure? Okay. Moving on to our next topic, that is equality of opportunity in public employment. Equality of opportunity in public employment. Okay, that is Article 16 for you. That is Article 16 for you. I'll tell you why. Because most of us skip these articles. Try to think of it. Mostly we just know very popular articles and that's it. Such articles that roam in the midway hold very important points and we generally miss them. How does that happen? See this, Article 16 that talks about equality of opportunity in public employment. Okay, this has anyway constantly been in news because Manrega, you'll see. Yeah, even recently in the papers, you've consistently seen the second version of it coming forward, right? The second version is coming forward where employment days are being increased from 100 to 125. However, there is a dark side to it as well. There's a dark side to it. Why? Because we are reducing the number of days of work, right? Because this has become optional now. This has become optional now, right? Number of enrollments are increasing, but number of days for which they are given work is decreasing. So this is the darker side. The public employment part is anyway in news every now and then. So you really need to understand this article very carefully. Okay, please pay attention. You really need to understand this very, very, very carefully. Is that clear? Yes? Okay. What are we saying? What does the article say? You have an equality of opportunity. In what matter do you have equality of opportunity? They are specifically talking about the matter where employment or appointment is regarded under state. Appointment or employment where under state. Okay, we're talking about employment under state. There can be no discrimination. No discrimination on what basis? What are the bases given? This is your question. This is your question that has a twist. Anywhere in flow, if you say that there should be no discrimination, there should be no discrimination on the basis of gender, caste, creed, place of birth, etc. That's how we go in the flow. Do we not? Right? There is your twist. There is your twist. Why? Because the grounds given here for no discrimination are religion, race, caste, sex, descent, place of birth. Religion, race, caste, sex, descent, place of birth. However, there is an exception in terms of place of birth. There is an exception. Why? Because state services only have a fixed quota for them. And even amidst that, scheduled areas do not even allow them to appear. You cannot go to a scheduled state, right? You cannot go to a scheduled state and say that I want to appear in your state services exams and I want to work. No. Place of birth is important here. Your residence area is important here. Yes, this is an exception, right? Another exception. If this is true, can I just walk up to any government office and say, give me an employment? Can I do that? Of course I can do that. Look at it. Everybody is entitled to a government job, irrespective of gender, caste, creed, whatsoever. If that is the case, I'm going, give me my job. Why are you not giving? Because discrimination is there. What kind of discrimination? Intellectual discrimination, because they are going to test whether you are up for the job or not. And that is how they discriminate on the basis of marks or merit. So this is allowing discrimination on the basis of merit. This article is specifically allowing discrimination on the basis of merit. Yes, this frames a certain question that what articles of India actually allow properly. They are subjectively allowing discrimination. And they're actually doing that. That is true. In all its manners, in all its glories, it is true if you look at it. Are they not saying that you should discriminate? Yes? Yeah. So that means discrimination is not allowed only on these specific grounds that are mentioned. These are very specific grounds that are mentioned. Merit is not mentioned here. Discrimination is allowed there. Right? Discrimination on other grounds. You can discriminate on the basis of language, yes. Yeah, you go to Punjab Civil Services today, they will ask you to speak Punjabi, write Gurmukhi, right? You don't know that? Yeah. So are you being discriminated on the basis of language? Yes. Did we say discrimination is allowed? No. So what happened? Discrimination is not allowed only on these grounds. Rest, full discrimination can be there. You understand that? At a point we begin to think that okay, nothing is left apart from this. Religion, race, caste, sex, everything has been covered. Yeah. If you want to enter into Punjab Civil Services, you don't have to be a Sikh. You can be from any religion, but you need to know Punjabi. You need to know Gurmukhi. Right? You enter into Maharashtra, you need to know Marathi. You enter into Gujarat, you need to know Gujarati. Language is the basis. Merit is the basis on which we can discriminate. Physical or intellectual ability. Physical or intellectual ability is a basis where we can discriminate. Intellectual ability, exam, merit, same. Physical ability, if it requires physical work, they have a physical test, long jump, high jump, throw and whatnot. If you don't qualify, do you clear the exam? If you don't clear the exam, will you be selected? No. That means physical requirements are also there. You can be discriminated because you are not tall, because you are not short. That discrimination is actually possible. You see, the examples we were taking in the beginning, right? They are actually reasons for discrimination that can take place under Article 16. That is the beauty of it. They're telling us we will discriminate, right? Is that clear? Yeah. That's why we say 16 comes up with a packet of exceptions. It is generally said that Article 16 comes always with a packet of exceptions. Why a packet of exceptions? Because the article itself has so many exceptions. The article itself. How? Let's take a look. 4 exceptions are there that we're going to talk about. Okay, 4 exceptions. Number 1, Article 16, Part 3. Okay. This specifically says that Parliament can discriminate on the basis of place of birth. On the basis of place of birth for certain public employment. It specifically says Parliament has the right to do that. Specifically said in the Constitution that we will discriminate. There is nothing you can do about it. Right? Amazing, right? So Parliament is saying that there are conditions for employment and appointment, and in union territories, local authorities, everywhere. Right? Yeah. Then comes 16.4. It has 2 parts, 4A and 4B. First, let's talk about 16.4 in general. State will provide reservation. If we are providing reservation to one, is it not discrimination with the other? Is reservation not a classic example of discrimination? So there is discrimination. Very simple. 16(4)(a) says that there will be reservation of seats in promotion as well for SC/ST. Right? Reservation in promotion for SC/ST. And 16(4)(b) is very clear, for carrying our unfilled vacancies, reserved seats, everything, carry forward rule. So that is also discrimination. But this is required discrimination that needs to be done, and that is being done for the upliftment of society itself. Yeah, but not to harm the society, instead to actually uplift the society. That is the difference. Okay, we are not trying to harm the society, we are trying to uplift the society, make it stronger, and anybody who has faced repression before, we are trying to make them strong. Is that clear? Yes. Okay, moving ahead, we had next article, that is article number 19. Article number 19 talking about protection of certain rights. Okay, article 19, that is specifically talking about protection of certain rights. What kind of rights are we talking about? Multiple rights. 19(1) that says right to freedom of speech and expression. Then 19(1)(b) that says right to assemble peacefully without arms. Then right to form association and cooperative societies, right to move freely throughout territory, right to reside and settle in any part of the territory, right to practice any profession. These are the specific rights that Article 19 deals with. Okay. Nothing, a very simple question for you. Which of the following rights are given under Article 19? Best question. Best question, if you look at the provisions, you'll be able to understand it is very easy to get confused. Very easy to get confused. How so? Just take a look. They're saying right to freedom of speech and expression. Yeah. Is it absolute right, or can it be, categorized? Huh? What would we do? It basically had 7 rights, but you see F is missing here. Right to property. Right to property that was transferred and made legal right. Why? Under Article 300A. Why did we do that? Why didn't we leave it here? We couldn't actually. We wanted to, but we really couldn't. Why couldn't we do that? And you see, this was like that job thing. So if having right property is a fundamental right, everybody went to Supreme Court and said, okay, give us property. Give me property because it is my fundamental right. You are supposed to give me that. Who is the protector of my fundamental rights? Supreme Court. And I want land. I want property. Now it is my right. I'm not being given the property. So whom do I go to? Supreme Court. So I'll ask Supreme Court, give me property. Simple, right? Quite amazing. You just go and ask Supreme Court, and Supreme Court gives you like, okay, take this 5 acres. Enjoy. Good, right? Yeah. So Supreme Court thought, okay, this is really getting annoying now. We need to shut you all off. So you all need to shift to legal right. It is legal right to own a property, but not our responsibility to give you that property anymore. Yeah, that's why the shift was made, and we made it what? Legal right under 300A. Is that clear? The rest of the rights are the same. Rest of the rights are the same. They have conditions. You can assemble, but without arms, right? You can assemble without arms, yes. So rights of citizens, and obviously because state has all the power to put on reasonable restrictions here. Yes, state has all the powers to put on reasonable restrictions here. Is that clear? Yeah. Therefore, can we say Article 19 is not an absolute right? This is not an absolute right. Reasonable restrictions can be put up. Can be put up. Is that clear? Yes? Exactly. That is why 19 is important. That is why 19 is important. Reasonable restrictions are here. Clear? Yeah. That's about it. That's about it. Coming forward to Article 21, right to life, popularly known as right to life. It is actually, it has broader aspect than that, but it has been popularized as right to life. Article 21. Okay. 21A, as we will come to, right to life, obviously. Personal protection of life and personal liberty. What is this article? Protection of right, life and personal liberty. Clear? Yeah. We will come to that, but before that, tell me one thing. Tell me one thing. Do you understand the concept when we say that I have the right to life? That means I can stay alive. Yeah? Okay. If I have right on my life, why cannot I end it? The question is, if I have right on my life, why cannot I end it? Why is suicide a crime? Why? You are saying right to life. Yeah. I have right on my life. Why is Santhara a question? Why is euthanasia such a big discussion? Why? If I have the right, why not let me enjoy it? Let me have fun. Right? Yeah. Okay. And if we have right to life, can you say right to life is absolute? Right? Is there any, can you think of any circumstance where right to life should not be given? Or do you think this is absolute? Like right to life is such a basic right? Everybody should have that. Yes or no? Or do you want some particular caste, creed, religion, gender, or something to not have a right to life? No. Everybody should have, yes? Do you all agree on that? So we all agree that everybody should have right to life. Yes? No? Why? Punishment. Exactly. What is it? Punishment. Capital punishment. To be specific. How will you give capital punishment if this is absolute? Right? Yeah. So this is available for both citizens and foreigners. Please remember that as well. A very classic question by UPSC is that which of the rights are available for citizens and foreigners? Please remember that, okay? Yeah. So naturally, this is not absolute, right? In the recent case, there was euthanasia as well. The person had been on ventilator for some 14 years. You remember that? Yes? A student who fell from the 4th floor and then hit the head and went into coma and had been in coma for 14 years was now finally euthanized. Have you read the case? Yes? Yeah, so this becomes important. Okay, that's why this is important and always in news. Clear? Yes. Now remember, another question for UPSC. First of all, it was available against state only. Against, this right is available against, was available against state only. In January 2023, recently, in January 2023, Supreme Court came up with the judgment saying that this can be availed against private individuals as well, not necessarily just state. Clear? What did they say? That this can be taken against private individual as well and not just state. Do you understand that? This is again for your prelims. Is it available against state or is it available against private individual? Against both. Yeah. Against private individual and entities as well. Is that clear? The right is very simple, okay? It includes a lot of things. right? There was this important case. There was Menka Gandhi case. Remember that? Yes, we have Menka Gandhi case, 1978. In this case, Menka Gandhi said, okay, you are giving us right to life. That is very good. Thank you so much. But tell me one thing. Tell me one thing. What is this right to life? If you're saying just staying alive is right to life, then this dog outside your court is also alive. Do you want us to have same kind of life? Right to life, what does it entail? So she raised a very good question that even animals are alive. Like, what is the point? What is the point? If you just keep somebody alive, if I just keep my child alive, right? She said that if a mother or a parent or the family just keeps the child alive, no schooling, no extracurricular activities, no developments, nothing else, just keeping him alive, feeding enough so that the person stays alive. Would you approve that kind of life? No. So she said, define right to life then. Tell me what kind of life do you want us to have? That is when court came up with right to live with dignity. What kind of life do we want to have? Right to live with dignity. Right? And from here the debate came forward that if you have the right to live with dignity, you have the right to die with dignity as well. Then why not allow Santara, euthanasia, etc.? Right? Yeah. So this has raised a debate that if you have right to live with dignity, why not right to die with dignity? Yeah? Exactly. Right to life includes right to live with human dignity and every aspect that goes, because your life has to be meaningful, right? You cannot just live to live. Your life has to have meaning. And to give that meaning, to give that meaningfulness, right to life was defined. Like you have right to privacy, right to good environment, right to food, right to electricity, right to good sleep. You know, constantly disturbing someone in their sleep is also considered a form of torture. That is punishable. That is punishable, yes. Because you're interrupting their right to peaceful life, peaceful sleep in their peaceful life. That is punishable, yes. Amazing, right? Exactly. So you have right to sleep. Next time somebody wakes you up, Supreme Court. No. See. All right. Do you understand Article 21? Yes, is that clear? Menka Gandhi case is clear? Yes? All right. Then we have two things, that is procedure established by law versus due process of law. Okay. Procedure established by law and due process of law. What are these two things? Let's understand. Number one taken from British Constitution, the other taken from US Constitution. Somehow this is the case always. Okay. So scope is that procedure established by law it is only assessing the process of lawmaking. Okay. How you are making a law, the law making is being judged here, the procedure is being judged here, and that's all. Nothing else is being considered. In terms of due process of law, they examine the procedure plus the substance. Okay. What does that mean? They check the intention also. Right? They check the intention as to by what intention, with what intention this has been brought. For example, if we talk about procedure established by law, reservation would mean discrimination. Yeah? Reservation would mean discrimination. And if we see due process of law, we will say that reservation is a necessity. Reservation is a necessity because we are seeing the intention and substance behind it. Do you understand that? Yeah. So our constitution only mentions procedure established by law. However, indirectly we also follow due process of law. It is not mentioned in the constitution explicitly. Please remember that. Another question for you. Has it been mentioned? No. Only procedure established by law is mentioned in the constitution. In which article? In article 21. Is that clear? Yeah. Due process of law? Not mentioned. It is not mentioned, but we do follow that indirectly. Reservation, classic example. Is that clear? You understand that? Yes? Very nice. That's about it. Now another aspect is that what happens to Article 21 during emergency? Right? What happens to 21 during emergency? The only thing that you need to know, earlier it was set up such that under Article 359 or under national emergency, it was said that Article 21 can be taken away. Article 21 can be taken away. Now remember the emergency? Remember the national emergency? The 1970s era, the popular 1970s emergency, yes. Yeah. So during this emergency, in the name of internal disturbance, so many human rights were violated, that this was decided no matter what, there was an amendment, 44th Amendment, 1978. What did they decide? That no matter what, Article 20 and 21 cannot be taken away under any circumstances, except for the law, of course. If you're breaking the law, then everything is on the table, right? In terms of emergency, 20 and 21 will not be taken away, no matter what. It will not be taken away, cannot be suspended. Simple. Is that clear? Yes, do we understand that? Yes? All right. Clear? Perfectly clear? That's about it. Coming on to our next article, that is Article 32. Article 32. Sorry. Coming on to Article 32, very specific article, talks about constitutional remedies. For in case your fundamental rights are violated. When do we use that? In case your fundamental rights are violated, what will you do? You have the right to approach High Court plus Supreme Court directly. See, we have a concept of integrated judiciary. Yes, we have integrated judiciary, right? And if we have integrated judiciary, that means we have to follow the path. Subordinate court, High Court, then Supreme Court, right? In case of fundamental rights, this procedure has been skipped. And we have been given the right that if your fundamental rights are violated, if the question is about your fundamental rights, you can directly go to Supreme Court. Now, that doesn't mean you cannot follow this. You can go to High Court also. But you have the right to directly go to Supreme Court. Is that clear? That does not mean that you necessarily have to go to Supreme Court. Please remember that. Students get generally confused that for fundamental rights, we have to go to Supreme Court. No. You can go to Supreme Court. There's a difference. You don't have to, but you can. Clear? You can go to High Court also. You can go to Supreme Court also. First thing clear? Yes? So we'll go to Supreme Court directly in terms of fundamental rights violation. What will Supreme Court do? They will issue a writ. What is the writ? the method of constitutional remedy. The methods of constitutional remedy that will be issued here. Is that clear? Yes. So through these methods of constitutional remedy, what is Constitution going to do? What is Supreme Court going to do? They have 5 kinds of writ. Sorry. They have 5 kinds of writ that they need to follow. Okay. Yeah. What do they have? 5 kinds of writs that they need to follow. Yes? Yeah. What are the 5 kinds of writs? Habeas corpus, mandamus, certiorari, quo warranto. Okay, these are the writs, sorry, prohibition. Yeah, these are the writs that the court can issue in terms of violation of fundamental rights. Other actions can also be taken. It is not necessary to issue a writ, but in certain circumstances, they have the right to issue a writ. One of the 5 writs that can be issued here. Yeah, exactly. Why would they issue a writ? Why would they issue a writ? Because they want to make sure that, whatever decision is being taken is well within the authorities. Okay. Yeah. To make sure of that, we have 5 kinds of writs. Right? Yeah. Let's talk about them one by one. Number 1 is habeas corpus. Yeah. Number 1 is habeas corpus. Do you understand what habeas corpus is? Habeas corpus means present the body. It means, literally it means to present the body. This right is used when, let's say somebody has been arrested. They have to be presented before the DM or before the judiciary within 24 hours, before the magistrate within 24 hours, yes. They have to be presented before the magistrate within 24 hours. This is the requirement. If they are not presented, they can say that we were not presented. They will say that we were not presented and they will go for the writ of habeas corpus. Court will ask them to present the body and they will say that if you have kept them for more than 24 hours, of course holidays and all that adjusted, if you've kept them for more than 24 hours, you have to release them immediately. No bail required. Nothing, no procedure. You release them immediately because you were wrong. To keep them here for longer period. Yeah. And this can actually lead to, a very, difficult culprit or somebody you have caught with large difficulty walking away. They can walk away because of this, because they're allowed to do that. Yeah, they are allowed to do that. Why so? Why do you think that is? Think. Why do you think that is? Any idea? No? See, what happens is, just try to understand a case. What happens is, when a person is arrested, they are presented before the magistrate. Magistrate will give an arrest and then they will issue a bail and everything will follow. But when you do not produce them before magistrate timely, that means you've already taken over their rights. So they cannot go further with any other punishment right now, right? That's why they have to leave them out and leave. This is our habeas corpus. Do you understand that? Habeas corpus. Next writ is mandamus. What do you understand by mandamus? What do you understand by mandamus? Tell me quickly. What do you understand by mandamus? Anything. Huh? It means we command. What does it mean? We command. Okay. It means we command. What do we command? The question is, what do we command? Court is trying to issue an order. Okay. Court is trying to issue an order saying that we command you to do this. We command you to do this. Do what? Whatever is the guideline, whatever they are offering. Right? Why? Because somebody has, not performed their duty. Somebody is not performing their duty, and we are commanding them to perform that duty. We are commanding them that you do this, you better do this, or we won't let you go. Or we won't let you go. Is that clear? Is that clear? Yes? Yeah. If somebody is not performing their duty, that's what we say. We command you to do this. You should be doing this. Why are you not doing this? Court will ask. Right? Yeah. If somebody wants documentations, let's say, they go to the e-Mitra and all these kiosks that we have through which the documents are made. They do everything and they just deny them that because we don't like you. For whatever reason, we don't like you, we're not going to do your work. They'll go to another kiosk. They also deny. Right? And even if they don't go somewhere else, why would a person be allowed to have that right to deny them service? They can issue a case against the person. They will be questioned, like, we are commanding you to do your duty, so do that. You understand? Yeah. That is mandamus. That is mandamus for you. You can use it to enforce contract, against even against Indian president or governors. See, the beauty of this is it can be done against president or governor as well. That is the power of writ. That is the power of writ. Yes? Yeah. But the twist is, please remember that since Supreme Court is not superior, Constitution is superior. If they are not following Constitution, we don't generally put writ on them because we cannot arrest them. So we just go for their removal. That's why we say it can be done, but it actually cannot be done. Do you understand this? Just understand it can't be done. Remember that. The confusion is that generally people think that, okay, it can be done. Why it can be done? Because it is done against every individual, every part of the state. But president and governors are not counted here because in case of president, it will directly lead to impeachment. Right? So that's why the impeachment process starts, not the writ process. Clear? Yeah. So it cannot be brought against president or state governors. Yeah. CJI, acting CJI, these are just exempted from that. Clear? Yeah. Next is prohibition. Next writ we have is prohibition. Yeah. Let's talk about prohibition. Okay. What is prohibition? To forbid. What does prohibition mean? To forbid. This is like, the elder sister. Don't do this. That's how they do, right? Any elder brother or sister that you have, cousin or whomsoever, right? Don't touch my stuff. Don't move my computer. Don't eat my chocolate in the fridge. Prohibiting everything. They're prohibiting everything. That is what prohibition is. We prohibit you from doing this. Like, this is the action you are going to take. We know that, and we are prohibiting you from doing that. Right? This is like any court in higher position will issue prohibition writ for lower position court. Okay? So that they don't exceed their jurisdiction. Higher positioned court to lower positioned court. Okay. Why? when they feel that any of this sorry for that, when they feel that any of these are extending their jurisdiction, right? Any of these are extending their jurisdiction, that's when, like for example, High Court is going beyond its jurisdiction, Supreme Court will come. How did you do that? Stop it right now. And if lower court, subordinate court is doing that, High Court will jump. High Court will issue a writ and say, stop it. That is prohibition for you. Yes, you don't surpass your jurisdiction, you don't move ahead your jurisdiction, right? Yeah, but understand, this is only for judiciary. This is only for judiciary. This cannot be issued against legislative. Okay, this cannot be issued against administrative, these bodies. No, only judiciary. Only judiciary. That is the important thing about prohibition for you to remember. Okay, that is the important thing about prohibition that you need to remember. Is that clear? Yeah, done. Next we have is certiorari. Next we have is certiorari. Yeah, certiorari means to be certified or to be informed. To be informed. So this is also used by the court. What court will say is that higher court, again to the lower court or tribunal, they will order that if you have a case pending, transfer it to us. Transfer to higher position court. Any higher court, like lower courts will go to them like that. Yeah, any higher court that can be transferred, right? And to quash their orders, like if you're saying that we have a large pendency, right? And if you have like excess of jurisdiction or lack of jurisdiction, or there's an error in the law, whatever reason can be cited, and they can demand for the cases, like this case is with you, I need that, give me. And they will have to follow and give that case. That can be transferred over. Clear? Is that clear? Yes? All right. That is certiorari. Next is quo warranto. That means by what warrant? That means by what warrant? Yeah. By what warrant are you doing this? By what authority are you doing this? So Supreme Court will ask High Court or the subordinate court and say that by what warrant are you taking these actions? By what warrant are you doing this? So court still has the right here. Yes. Court will again ask the same question and repeats it. Yeah. By what warrant are you doing this? By what authority are you doing this? And who gave you the permission to do that? Right? So court can still ask that. Clear? That is how quo warranto is used. Inquiring the legality of a claim, any which way. Right? Yeah. So these are our writs. Let's revise all of them one by one. First of all, we have habeas corpus, that means to have the body of examining the legality of detention, 24-hour case, yes, against both private and public. Mandamus, we command imposing mandatory legal duties against public officials, bodies, inferior courts, etc. Prohibition, to forbid, preventing a lower court from exceeding jurisdiction against judicial and quasi-judicial authorities. Then we have certiorari, to be certified or informed, giving the information that transferring a case, quashing an order, all these things. Quo warranto, by what authority or what warrant are you doing this? That can be questioned and that is being questioned. Yeah, exactly. So this is our Article 32 writ, and with that we finish up our topic of fundamental rights as well. Is that clear? Yes? Okay. Moving on to our next topic, that is DPSPs. I hope the fundamental rights part is clear. DPSPs is another big topic. After that, we'll have very small topics. Okay. So we'll finish them up quickly. Right now, we are starting DPSPs. I hope fundamental rights were clear. Yes? Absolutely clear? Sure? All right. Okay, let's move forward and let's start with our concept of DPSPs, shall we? Yes, 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 yes. Okay, okay. Tell me, what are DPSPs? Tell me. What are DPSPs? Directive Principles of State Policies. Okay, very nice. Directive Principles of State Policies. Part 4, Article 36 to 51. Yeah. Directive principles. See, what happened was all the fundamental rights could not have been given right away. So some of the rights were transferred to DPSPs for later on. Okay. These later on rights are DPSPs. States, whenever they are formulating a policy, they have to keep these rights in mind. They have to keep this direction because this is the direction we want India to move towards. We want India to be a kind of nation that can provide these rights. Is that clear? Yes? Exactly. This is the kind of future we want. That is DPSPs. That defines DPSPs. That the kind of future. That's why B.R. Ambedkar said that they are novel features of the Constitution. They are novel features of the Constitution. Who said that? B.R. Ambedkar said that. Right? Yeah. Grenville Austin said they are the conscience of the Constitution. Conscience of the Constitution. Chetana. Yes? Yeah. These are our DPSPs. Let's talk about them. Okay, let's talk about the specific DPSPs that we have. What kind of DPSPs do we have? Yes, fundamental duties and DPSPs. Very small topics. All together, we will see what DPSPs are there. You just have to remember that the details that you already know. 36, definition of state, same as Article 12. Same as Article 12. Okay, yeah. 37, application in this part, same as 13, like we were defining law there. We are defining here the application. Yeah? Yeah. Similar. 38, states are securing social order for the promotion of this. 39, principles that states have to follow. Certain principles that states must follow. 39A, equal justice and free legal aid. We are providing free legal aid to the people, making sure that they are getting the benefits out of it. Yes? Making sure they are getting the benefits out of it. Do you understand that? Yes? Yeah. Everybody should have the right to adequate, legal help, legal force, legal protection. That should be provided to them equally. Yeah. Article 40, Organization of Village Panchayats, that has already been done through 73rd Amendment Act. Yes, did we do that? This is Gandhian principle. Gandhian principle, because we have DPSPs in 3 forms. Liberal, Gandhian, socialist or welfare. Yeah. So this is Gandhian principle. Very nice. Article 41, right to work. If we have the right to work, we have right to public assistance as well. 42, provisions for just and humane work conditions. Just and humane work conditions. Why? Because you're working, that's fine, but you need to work in humane conditions. That is not like just because you're getting money, you can be treated any which way, right? That doesn't work. Clear? Then we have 43, living wages. 43A, participation of workers in management and industries. Anyway, coming to the cooperative societies that have also been given space in fundamental rights also. 44, Uniform Civil Code, the thorn that government has today, because they've tried to do this, but they're not able to do this. We have been trying for very long, but then again, the diversity just doesn't make it easy, does it now? Article 45, early childhood care. This was amended by 86th Amendment 2002. Why was it amended? Because earlier it talked about 6 to 14 years of age. 6 to 14 years of age. Then by 86th Amendment 2002, what we did was 6 to 14 was made fundamental right. Education for the children of the age 6 to 14 was made fundamental right. So here there was a vacancy. There was a vacant provision. So what we decided was, instead of repealing it, we put here 0 to 6. Instead of 6 to 14, we focus on 0 to 6, that is primary education. Yeah. Okay. Yeah. Then 46, scheduled caste, scheduled tribes, other weaker sections. 47, nutrition level rise. 48, agriculture, animal husbandry. 48A, environment, safeguarding forest and wildlife. What are we safeguarding here? Forest and wildlife. Yeah. If we are talking about forest and wildlife, please remember that in terms of this especially, just please remember that agriculture, animal husbandry, environment, forest, this was also inserted by 42nd Amendment. This was also inserted by 42nd Amendment. Clear? Is that clear? Yes. 49, protection of monuments and places. 50, separation. The article consistently in news, because everybody is trying to overpower today. Judiciary wants to say I am superior, Parliament wants to say I am superior, executive is like hello, I am also here, right? So everybody is trying to overpower, and Article 50 has been consistently in news because of that. Clear? 51, we say we're promoting international peace and security. Right? These are our DPSPs. You just generally have to learn all of them. Most of them have had certain provisions to apply them, to implement them. Some are missing, like Uniform Civil Code. Some states have tried to do that. Goa has UCC, right? Some states or UTs have tried to do that, but other than that, we don't have any provisions, right? For all other DPSPs, we have some or the other kind of provisions trying to implement them. Clear? Yes. Now, one thing that you have to remember, one thing that you have to remember here is that there are certain directives outside of part 4, that is UPSC's favorite question. Yeah, which are the directives outside of part 4. Okay, so there are 3 major directives that we are talking about. Article 335, first of all. Okay, Article 335. Care to guess what this might be? Okay, claims of STs, SCs to services. Okay, these are directives that you have to follow that. Then 350A, instruction mother tongue. Instructions in mother tongue. This is also considered as a directive, but it is outside the scope of part 4. Development of Hindi language, 351. Yeah, this is also a directive. Development of Hindi language. Is that clear? Yeah. This is also what? A directive outside of part 4. Please remember these. Please remember these. They are consistently asked. They're consistently asked. Yes? Yeah. They're outside of part 4, but still they are considered as directives. Clear? Yeah. Okay, so we've studied a lot. Let's solve a few questions once again. Yes? Yeah. Let's get you energized. Okay. So you're getting a question, try to read carefully, try to answer carefully. Okay? Yeah. Go ahead, give me your answer. Give it your best shot. Okay, very nice. The answer is B, the Preamble and DPSPs, which is economic justice as the objective, which has economic justice as the objective. Preamble and DPSPs. Very nice, very nice, very nice. Let's solve just one more question, then we'll move to our next topic. Just one more question. Which principle among the following was added to DPSPs by 42nd Amendment to the Constitution? By 42nd Amendment to the Constitution. Tell me. Solve quickly. Done? Yes. Are we done? All right. The answer we have is B. Participation of workers in the management of industries. All right. Yeah. So this was the topic for DPSPs. Moving on to our next topic, that is fundamental duties. That is fundamental duties. What are the fundamental duties? What duties do we have? How was it added? We'll see to all of that story. Okay, shall we start? All right. Let's understand what fundamental duties are. First of all, remember a statement. Fundamental duties were added on to the Constitution by an amendment. Okay, we added on the fundamental duties by an amendment that came with the recommendation of Sardar Swarn Singh Committee. Okay, Sardar Swarn Singh Committee. All right, now through their recommendation, we added fundamental duties to our Constitution. First of all, is that clear? Yes, is that clear? Fundamental duties are non-justiciable in nature. The other thing that you need to remember is that they are non-justiciable in nature. That means they cannot be enforced in a court. Yes, what does that mean? That means that they cannot be enforced in a court. Is that clear? Yes. Okay. If they cannot be enforced, then why add? Why add? Yeah. No legal sanction. They are moral and civic in nature. That's why they bring out the morality and civic sense of people. That's why they were added. However, they are only applicable to citizens. Only applicable to citizens, as against fundamental rights, which were also given to foreigners. Not all, some of them, but still they were given to foreigners. Fundamental duties, however, are only applicable to citizens. Is that clear? Yes? Okay. Now we've added fundamental duties. The question is, by which amendment? Yes? By which amendment did we add fundamental duties? By 42nd Amendment, we added fundamental duties. Is that clear? By 42nd Amendment, 1976. Sardar Swarn Singh Committee gave multiple recommendations. Some of them we did not accept. Yes? Yeah. We'll have a separate chapter on fundamental duties. This was decided. Balance should be there between rights and duties. This was decided. But we were not going to make it justiciable. We were not going to make it justiciable. Do you understand that? We came up with Article 51A. We came up with Article 51A, under which duties were added. Under which duties were added. Yes? Is that clear? Is that clear? All right. All right. Let's see what our duties are. We have multiple duties: abiding by the national figures, national anthem, national flag, respecting all these national figures. And then the second duty that we have, national struggle for freedom, the ideals and people, then upholding the sovereignty and integrity of India, defending the country and rendering national service when called upon, promoting harmony and brotherhood, right? Just all kinds of duties, and you have to remember what kind of duties are added in the Constitution, okay? More importantly, at the time of 42nd Amendment, how many duties did we add? We only added till J, that is 10 duties, okay? We only added till J, that is how many duties were added? 10 fundamental duties were added to the Constitution. At present, we have 11. How did that happen? 10 of them were added by 42nd Amendment, the first one. One more was added by 86th Amendment. Remember 86th Amendment we discussed in Fundamental Rights? Do you remember that? Yes, the same one. What it did was 86th Amendment added a provision for parents, for guardians, that you have to send 6 to 14 years, not 0 to 6, 6 to 14. Please remember that. Because we made this fundamental right. Now imagine a 6-year-old child being told, education is your right, you should take it. And then you ask him to go to school. You'll have to drag him. Come on, let's go to school. Children are not really happy going to school. Not all of them, at least. Some may be exceptional, but not all of them are happy, right? You have to drag them to school. Let's go to school, study. You tell them studying is your right, you should take. They'll be like, you take it, you go. Right? They wouldn't be very happy about it now, would they? So naturally, parents or guardians need to be responsible for the fact that you have to send them to school. You have to make sure that they are being sent to school. They are getting that education. That is their right. Okay. That was our 86th Amendment. Is that clear? Yes. So if I say a statement, originally, how many fundamental duties were there in the Constitution? How many duties are there? 10. Okay. At present, how many are there? 11. Yeah. Very wrong. Very wrong. Not just a little bit wrong, very wrong. Why? Because originally, Constitution had 0. How many fundamental duties? 0 fundamental duties. That's it. Why? Because even the 10s were added with an amendment, through an amendment, 42nd Amendment. Is that clear? Is that clear? Is that clear? Another one was added by 86th Amendment. Done? Done? Okay. So we had Sardar Swarn Singh committee for that. Sardar Swarn Singh, with all due respect, he came up with the suggestion that we should have fundamental duties. Okay. So now there were a few recommendations that they did make that were not accepted. Few recommendations that were not accepted. This is another favorite part of UPSC, that which recommendations did we not accept, right? The Sardar Swarn Singh committee was set up. They came up with multiple recommendations. Amongst them, 3 were not accepted. Number 1, paying taxes. Paying taxes should be a fundamental duty. This we did not accept. Okay. Second, Parliament may provide penalty or punishment. Penalty or punishment. This we did not accept because we made them non-justiciable. Right? So we did not accept this. The third one is no judicial review. No judicial review to take place in terms of any penalty imposed. So naturally, if we are not accepting penalty, this provision cannot be accepted, right? The 3 provisions that they recommended, we did not accept. Clear? Is that clear? Yeah. So this is fulfilling all the obligations. However, we adopted this, we finally adopted this, and we have our fundamental duties. Clear? Yes. That was our chapter on fundamental duties. Is that clear? Very clear? Any doubt? No? Next topic that we have is emergency. What is the next topic? Emergency, a very simple topic. We'll quickly finish this up. Okay. What are we to do about emergency? The only thing that we need to know is we have 3 kinds of emergencies. We have 3 kinds of emergencies. We'll talk about them. Okay. The most important one is national emergency. Okay, the most important one for you to discuss is national emergency. Why is it most important? Because the other two are, one is president rule, that keeps happening every other day, right? Do you know Chhattisgarh and Telangana? These are the only two states. Okay, we'll come to this. Wait. First, let me tell you something else. Then this will be fun. Okay, just wait for a minute. I'll come to this. National emergency, president rule, and then we have financial emergency. Okay. These are the kinds of emergencies we have. Financial emergency has never happened. Never. This happens every other day. So nothing good about this. Right? This happens every other day, so it has become very common. National emergency is a rare occurrence. Yes, this is a rare occurrence with a very dark history. You see, we have a dark history, right? Okay. I'll write just history. But we do have a history. Yes. So because of that, national emergency gains a lot of attention. Okay. And we can frame a lot of questions, because financial emergency never happened. Even in 1991 crisis, we adopted LPG, got loan from international agencies, but we still never declared financial emergency, right? So this has never happened. So there is no question to frame, like very basic. This keeps happening every other day, so very common. Exceptional content comes from national emergency. That's why this is very important. Okay. So the more focus we put on this, that will be better. Yes. So we will be working on emergency, national emergency. Which emergency? National emergency. Is that clear? Yeah. So three kinds of emergencies. We took this from 1935, Government of India Act 1935. Okay. Who announces emergency? President announces emergency. Please remember that, on the recommendation of COM. Who announces emergency? President announces emergency on the recommendation of Council of Ministers. Types of emergencies: national emergency, Article 352. President's rule type 1, 356. Financial emergency, 360. President rule type 2, 365. Why two types of president rule? First, let's talk about that. Number one, president rule comes when state machinery fails. When state machinery fails and governor calls president to take over. Okay. Second one is president rule type 2. What is president rule type 2? When state fails in obeying order, in obeying central order. If center gives an order to state, state has to follow within the given rights, of course. If center is giving an order to state, state has to follow. If they don't, we will consider that state has gone rogue, and that's why president needs to come. This is type 2. You understand that? This is type 2. That's why we say president rules are of two types. Two types of president rules. Clear? Yeah. Is that clear? So this is called constitutional emergency. This one we call constitutional emergency because constitutional machinery is failing down. That's why this one we call constitutional emergency. Is that clear? Yes? Okay. Coming on to national emergency. Coming on to national emergency, that is quite important for us right now. Now, national emergency is important because for this, an amendment has also been done. Constitutional amendment has also been done. That's why it becomes even more important. Yeah. In this respect, in president rules respect, we are saying that Chhattisgarh and Telangana. As I told you, this is so frequent that it keeps happening. It is so frequent that Chhattisgarh and Telangana are the only two states where this emergency has not happened. Every other state, it has happened once, twice, multiple times, on and on and on. Yeah. Chhattisgarh and Telangana are the only two states that have been left where president rule has not occurred. Clear? Yeah. Let's talk about national emergency. National emergency, what are the causes for national emergency? Like on what basis can we declare national emergency? Yes, we have three bases. War, external aggression, or armed rebellion. This armed rebellion was earlier internal disturbance. What was it called earlier? Internal disturbance. But on the name of internal disturbance earlier, because there was just disturbance in Punjab, Gujarat, etc., few areas, national emergency was declared by Indira Gandhi. Do you remember that? National emergency being declared by Indira Gandhi, yes? Yeah. So because of this, this was changed, like this is not a good basis. What is internal disturbance? What is internal disturbance? Two people are fighting. I'll just say that, okay, there is internal disturbance. I am going for national emergency. Internal disturbance can be anything. It is such a vague term, right? That's why it was specified into armed rebellion, stating that there has to be, the people have to be armed. They need to be fighting off, right? There should be a rebellion. That is the scale that should happen for you to declare national emergency. Otherwise, you cannot do that, right? Because national emergency is not a small thing. You take away the rights of the people, the entire system comes crashing down. It is not a small thing. It is not like you can do it any other day. No. So that's why this was replaced, and we replaced what? Internal disturbance with armed rebellion. 44th Amendment, 1978. Naturally, 44th Amendment, 1978, right after the fall of Indira Gandhi government, this was done. Clear? So now, national emergency can take away all rights, but remember the exception, except 20 and 21. 20 and 21. Another important thing for you to discuss is national emergency can be applied to whole or any part of the nation. It is not necessary for you to apply national emergency to entire nation. Even if you apply national emergency to some part of it, that would still be considered national emergency. A part of India can also be brought under national emergency, leaving rest of India outside of the scope. Clear? Do you understand that? That is an important thing for you to know for prelims. Yeah. Besides this, one other thing, when have we had emergency? So far, national emergency in India has occurred 3 times. National emergency, not all emergencies. National emergencies have occurred 3 times. Number 1, 1962 emergency, external aggression, India-China war. Reason was external aggression, India-China war. Okay, this was first one. Second one, 1971, India-Pakistan war. India-Pakistan war. Yeah. Reason was war. Then there was internal disturbance. Internal disturbance story we already know. Yes. Internal disturbance, Indira Gandhi. Internal disturbance, armed rebellion, whatever reason you call, that we've already discussed. Yeah. These are the 3 times we have come up with emergency. India had national emergency. Is that clear? Yeah. Okay. How do you apply national emergency? How do you Declare emergency. The declaration requires Parliament passing, Lok Sabha or Rajya Sabha passing resolution to apply within 1 month. Passing a resolution, okay, yeah, by special majority. Which majority? Special majority. Removal of emergency, however, requires only simple majority. Okay, yeah. Any house, Lok Sabha or Rajya Sabha, within 1 month of the proposal, they have to give that. First time emergency will come for 6 months. Can be extended for any number of times. Any number of times. Unlimited time. Okay. Unlimited time. Please remember this. Unlimited time. Okay. Please remember, there is no time boundation. There is no boundation. Any number of, but every 6 months you need reapproval. That is the condition that was added by 44th Amendment. Why? Because once you've had emergency, if it keeps going on, that means your tenure will keep going on. So they are using it as a tool to extend their tenure, to stay PM for long. Every 6 months you need approval. Once again you need approval. Once again you need approval. And if approval doesn't come, no emergency. Only for 6 months. 6 months at a time. For unlimited time, you can bring for 20 years, that's fine. But approval needs. There should be an approval. Yeah? You understand that? This was done by 44th Amendment. Is that clear? Exactly. That is our national emergency. That is our topic. Is it clear? Yes? Do you understand the important things for prelims to note? All right. Let's move on to next topic. Moving on to next topic, that is President and Vice President. Care to guess which one's who in this picture? Who's on the left side? Who's on the left side? Please don't say, ma'am, you're right or my right. Your left or my left. Please don't play that. Who's on this left side? The man on the left side and the woman on the right side. Yes, we have President and Vice President. Would you care to name them? Would you care to name them? Yes. No? Why? Don't you identify them? Yes? Okay. So basically, in President and Vice President, for President especially, we have two major things, that is veto power and then we have the pardon power. Okay. That is what we are going to discuss in detail. That is the veto power and the pardon power. Okay. Yeah. These two concepts we will discuss in detail. What is the veto power of President? Veto power has come up ever since governors during East India Company were given veto power and ordinance power. These powers are same. Yeah. Yes. So Lok Sabha, Rajya Sabha, President, all go through, the bill goes through all of them. When it comes to President, if a bill comes to President, President has a few options. President has certain veto powers regarding that bill, in consideration to that bill. What kind of veto power? Absolute, suspensive, and pocket. What veto powers? Absolute, suspensive, and pocket veto. Okay. Absolute, suspensive, and pocket veto. Now, absolute means withholding the assent, right? Bill will end and will never become an act. Simple. Withhold, no act. Simple. You withhold and then there will be no act. Example, 1954, Rajendra Prasad did in case of PEPSU appropriation bill. Example, PEPSU appropriation bill. Remember PEPSU? Yes, from history you must remember PEPSU, modern history. Yes, okay. Then we have suspensive veto. What is suspensive veto? Suspensive veto is president exercises this veto when they want to give back the bill for reconsideration. This is reconsideration, sent back to parliament. Okay, reconsider and then give me back this bill. That is suspensive veto by president, that okay, there are few changes that you need to make those changes and then come back to me, then we can talk, right? Yeah. Now, but remember, this veto is not available for money bill. This is not available in regards to money bill. When money bill comes, you have to sign. You have to sign. Okay. Yeah. This has so far been used once by APJ Abdul Kalam in case of office profit bill. That's all. Okay. Yeah. Next is pocket veto. Pocket veto is in no action. No action on the bill passed by the legislature. In this way, president is not ratifying, not rejecting, not returning, doing nothing. Just keeping it with them for indefinite period. Right? Now, this has been in news. This has been in news. Why? How can you keep it for indefinite period? There should be some limit to it, because this is just hampering the work. Hampering the work because people don't even know whether you have pocketed it or whether you are still thinking about it. Whether you are still taking time to decide on it or whether you have pocketed it. So this just leads to delay in the work. It doesn't seem practical, right? So this has been in question, pocket veto, that we should really change something, put a limit on it or remove the power altogether. We should do something about it, right? This doesn't sit right. Okay. Yeah, so pocket veto, indefinite period. This was used once by President Zail Singh. You remember? Yeah, exactly. The President Zail Singh who used this in Indian Post Office Bill. Indian Post Office Bill. Clear? Yeah. This is pocket veto. Clear? Okay. These are the veto powers. Next we have the pardon powers of president. Next we have the pardon powers of president. The pardoning power of president. Clear? Let's talk about that. What are the pardoning powers? President, even after Supreme Court, there is a way for us to get pardon. Right? Even after Supreme Court, there is yet another resort. However, Supreme Court is considered the highest authority of judiciary, right? But still after that also, we have president to go to. In certain cases, we have president to go to, right? President has certain powers that they can use to actually make changes to our punishment. Okay, they can make changes to our punishment. What kind of changes can he make? That we'll talk about. What kind of changes can he make? First of all, there is pardon. Okay. The first change is pardon. Pardon means completely pardon. Completely pardon means you are removing the sentence, the conviction, the chart, the data, everything. Like it will be like there was no crime, you had never been to police station. That's it. No FIRs, nothing. Every record is shut down. That is complete pardon, right? Conviction is done, your punishment is done, paperwork is done, everything is removed. There is no sign, it is as if there was no crime, there was no incident, there was nothing, right? That is what pardoning power is. Complete freedom. Complete pardon, like there was no crime. Like there was no crime ever. Yeah? Records are also removed. Please remember that. Records are also removed. Documents are also removed. Yes, all punishment, everything done. Second is commutation. The second one is commutation. Okay. What is commutation? Commutation is where substitutes one form to lighter form. Substitute one form to a lighter form. Example, Gandhi asked Irwin for commutation of punishment of Bhagat Singh, punishment of death for Bhagat Singh, Rajguru, Sukhdev, to a punishment of life imprisonment. Okay. So the gravity of the punishment kind of remains harsh. It's not like you're making it very easy for them. No, that remains harsh, but still we change the nature. Right? Lighter form, a lighter form. Clear? Yes? Yeah. This is commutation. Clear? Next we have remission. Next we have remission. What is remission? Remission is reducing the sentence. Reducing sentence without changing the nature. Without changing the nature. Right? Yeah. How so? Like the nature is isolatory. Okay. Solitary confinement. Let's say the nature of the punishment is solitary confinement. Solitary confinement is for 1 week. You are negotiating that solitary confinement be reduced to 1 day, 2 day. Okay. It will be reduced to 1 day or 2 day, but it will still be solitary confinement. You understand that? Without changing the nature. The nature of the punishment cannot be changed. Earlier we were changing the nature of the punishment from death sentence to life imprisonment, right? In this, nature won't change, time period can change, right? And when you're asking for time period change, that would be remission. Is that clear? Yeah? Okay. Now the change of punishment when it is done under special circumstances, okay? Next one we have is respite. In respite, when you are changing the punishment under special circumstances. Special circumstances, what are these special circumstances? Like pregnancy, okay, handicapped. If somebody is handicapped, now you cannot give them the punishment of picking up rocks and building constructions and whatnot, right? If they're not capable of doing that anyway biologically, how would you do that? Then if in case of pregnancy also you cannot say, because if you are giving such punishments in pregnancy, you are not actually giving punishment to the mother, but you are giving punishment to the child. The child will suffer because of that. Child is innocent, right? So naturally we cannot do that. So we'll go for respite. Okay. Yeah. Last one is reprieve. Last one is reprieve. Okay. Reprieve is temporarily you put a stay. Temporary stay on execution to give a chance. This is generally done when, the date of execution is very near. Let's say that today the person has been told that you can go to president, but the date of execution is like 3 days later. So for now, to go through the hearing, to let president decide, etc., and to allow the person to actually make a request, we need to give them some time, right? So we'll do what? Temporarily we'll push the date. Okay. Let's say if you're going to be hanged 3 days later, we'll give you a month. A month later you'll be hanged. But until then you have the right to approach us with any of these options that you're applicable for. Pardon, commutation, remission. Respite is like very rarely applicable on everybody, but still, if it is, then you can come, obviously. Remission, commutation, pardon, whichever one you want to apply for, whichever one president would deem fit would be given to you, but you have to apply for that, and for that your hanging date would be shifted forward, and that's why this is used. Clear? Yes, that is reprieve for you. Is it clear? Yes? Yeah. Now see, the important thing here is that governor also has the same powers. Governor also enjoys some powers, but pardoning powers are there. Limitations, they have limitations. What kind of limitations? Remember these again, once again, a favorite topic of UPSC, Once again, please remember there are certain limitations. What are those limitations? The limitations are, number one, they cannot pardon punishments given by court martial. They cannot even hear that, right? Yeah. Then they cannot completely pardon death sentence. That only president can do. If somebody has been given death sentence, you can commute it, commutation is allowed, reprieve, respite, you can use every other thing on this, but you cannot completely pardon the death sentence. Only president can do that. Right? Yes. So governor can also pardon. Then special power under state law, governor will work, not president. Right? Under state law, governor will work, not president. Yeah, that is president's power and that is governor's power. Do you understand the comparison? A very important thing, favorite thing of UPSC, comparing president and governor and their positions and powers. Do you understand that? Yes? Do you understand that? Okay. In terms of veto also, governor has the same powers. In terms of veto power also, governor has the same power. One extra veto is added. That is, reserve the bill for president. Reserve the bill for president. This is an extra power that governor has. Okay. In terms of veto, that is reservation veto. Reserving the bill for president. This is also considered a veto power of governor that governor has, but president does not. Okay. Is that clear? Moving on to vice president. Vice president, ex officio chairman of Rajya Sabha. Ex officio chairman of Rajya Sabha. Who is vice president? Ex officio chairman of Rajya Sabha. Yes? Is it? Do you know that? Who is the vice president? Do you know him? Yes. Now, there are certain things you need to know about vice president's position as well. What kind of position? First of all, origin, we come from, where do we come from? American idea. The idea is American. Okay. Constitutional provisions 63 to 71. Article 63 to 71 we have vice president. Election, they are indirectly elected. They are indirectly elected. Is that clear? They are indirectly elected. Is that clear? Qualification, age 35. Age comparison is generally asked. Please remember, age is 35, 5 years of office, 5 years of office. If you say first vice president, who was the first vice president? Who was the first vice president? S. Radhakrishnan. Very good. S. Radhakrishnan. Clear? Okay, very nice. Then, first, who's the current VP? Current VP, we just saw them. Yeah, that is upon you. Do the homework. Okay. Term, 5 years. Term, 5 years. Removal, they can resign. Whom do they submit their resignation? President. Whom do they submit their resignation? To President. Is that clear? They will give their resignation to President. They are ex officio chairman of Rajya Sabha. They can also act as President. Can act as acting President for continuous period of maximum 6 months. Yeah, maximum 6 months. Clear? Yeah. This is Vice President for you. This is Vice President for you. Is that clear? Moving on to our next topic, that is Parliament. What is our next topic? Next topic is Parliament. Coming to Parliament, our Parliament has 3 organs: Lok Sabha, Rajya Sabha, and President. President we have already discussed. Okay. We'll talk about Rajya Sabha mainly because Lok Sabha is very common. Executive and all will cover there, but we'll talk mainly about Rajya Sabha. Rajya Sabha holds great importance here. Okay. So our major focus will be on Rajya Sabha. Let's start with Rajya Sabha. What are the powers of Rajya Sabha? Okay. See, Rajya Sabha will work as any other house. It is a permanent house. Okay, not dissolved. Members keep retiring. Members keep retiring. 1/3 members every 2 years. They keep going, right? Retiring. And that's how new members keep coming in, right? So Rajya Sabha has similar functions, discussions, passing of the bill, all these things, right? But in certain scenarios, Rajya Sabha has special powers. Special powers, and in some cases they have no power. Okay. No power, example, money bill. Right. There they have no power. Special power, example, creation of new All India services. That can only be done in Rajya Sabha. That can only be introduced in Rajya Sabha. Procedure for the removal of VP. Procedure for the removal of VP, that can only be brought in Rajya Sabha. These are their special powers. Okay. Through these special powers, we define the whole structure. Okay. We define the whole structure and we try to, understand what powers Rajya Sabha holds, or what kind of, we'll say, what kind of aura Rajya Sabha holds over Lok Sabha. Okay. But to define that, we need to understand Rajya Sabha as a permanent house is the representative of states. Okay. Yes, is that true? It is a representative of states. And while being a representative of states, it has nominated members as well. Nominated members. Yes. Amongst those nominated 12 members, members who have expertise in different areas, they are also hired. Are they not? Definitely they are hired. And now, through these expertise, Rajya Sabha not only becomes a representative of state, it also becomes a representative of different arenas of knowledge that are active in India. Different arenas of knowledge. Do you understand that? Yes? Yes, do you understand that? Yeah. Now through these, special, what would you say, powers, special work, what they have done is, they've set up such a structure, that they are very important. And in terms of these importances, you'll see the powers, one power that Rajya Sabha doesn't hold, another one power, very specific power that Rajya Sabha doesn't hold is joint sitting. Because when Rajya Sabha says no to something, there's a provision for joint sitting. Joint sitting is generally tilted towards Lok Sabha. Why? Because Lok Sabha's speaker will head what? Joint sitting. Lok Sabha speaker will be heading joint sitting. Parliament president will call the joint sitting. Lok Sabha speaker will lead the joint sitting. Rajya Sabha has no power into that. But this joint sitting cannot take place in terms of Constitutional Amendment Act, okay, and in terms of money bill. These are outside the purview of joint sitting, because basically joint sitting can only be called for ordinary bills. Okay, we have different kinds of bills: ordinary bill, money bill, financial bill, constitutional amendment bill, but joint sitting can only be called for ordinary bills. Please remember that. Only be called for ordinary bills, speaker will head, president will call, Rajya Sabha has no power. They just come, sit, vote, that's it. Is that clear? Yes? Yeah, that is the provision of joint sitting. Clear? Yeah. Coming on to next thing, that is parliamentary motions. Have you heard of parliamentary motions? Like anything that you know, regarding parliamentary motions, like what are they, what kind of motions do you think exist, and why would they come up, like what would it entail? Anything. See, motion means making anything move, right? Parliamentary motion is also like there are provisions, there are recommendations, there are new ideas that have been put forward and that need attention. Okay, so in the parliamentary sessions, we have different time hours. Like the first hour is question hour, right? The first hour is question hour. Same way we have hours for motion as well. Okay, so different kinds of motions are brought forward. Like the first one is adjournment motion. Okay, adjournment motion. The first one we have is adjournment motion. It is moved to discuss something of definite, urgent public importance. Definite, urgent, public importance. Anything that is so important that it is definite and very urgent and important for the entire public, that needs to be discussed right away, right? Immediate concern. This will be brought up with speaker's consent, of course, right? But this needs to be discussed immediately. Yeah, that becomes what? Adjournment motion. For that we will have 50 members support. At least 50 members need to agree that matter seems so important that we need to stop everything that is going on in the house and start this. Now this is only in Lok Sabha that we can do this. Only in Lok Sabha, not Rajya Sabha. Right? Yeah. Is it clear? Yeah. That is adjournment motion. Second one we have is closure motion. Okay, the second one we have is closure motion. What is closure motion? Closure motion is basically to cut short the debate, whatever is there, and if it is approved, we'll just stop the debate and put the matter to vote. That's it. Like closure motion is brought that somebody will stand up and say, okay, we've discussed this enough. It is done now. Debate is never ending, right? So somebody would get up and say that, okay, let's put it to vote. I am done with this. So this motion will be passed. If everybody says yes, 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 let's put to vote, let's put to vote, let's put to vote. So the matter will be considered closed, that we have discussed this enough. Let's start voting. That is closure motion. Very simple, right? Cut the debate short and put to vote. You don't necessarily need to cut it short. You can say that we've finished it, we have discussed this enough. Yeah, that can also be closure motion. Then comes motion with the vote. Okay, short duration discussion, no confidence motion, right? Yeah. No confidence motion. No confidence motion is brought upon to check whether government still holds, majority. If government still holds majority and if they can rule. Okay. If this is passed, government has to resign. If passed, government has to resign. Okay, government will be dismissed and they have to leave the floor. President will prove their majority on the floor. Passage will be like government has to go. Clear? Yes. Obviously, this also needs 50 members support, because you cannot bring every other day motion to a no confidence motion to disrupt the government, can you? Yeah, you cannot do that every other day. That's why this is done. Clear? Yes? Do you understand that? Next one is calling attention motion. Calling attention motion. What is calling attention motion? Calling attention motion is like there's a matter of public importance that you want everybody to pay attention to. So you'll bring that up and you'll ask everybody like, okay, this is a matter and we want to discuss this. But this is different from adjournment motion. Okay, this is different from adjournment. How is it different from adjournment? In adjournment, we had seen that we will take 50 members support, and that is how we will try to bring this down. Okay, so calling attention, what happens is this is like bringing an attention, everybody's attention, minister's attention, authoritative statement, etc. to a motion. Okay, so here we don't need to stop all the functions of parliament, right? In adjournment, we required them to stop everything they were doing in the session, stop them midway, then discuss. For this, they just want an answer. That's it. Yeah? Do you understand that? Clear? Okay. That's it. These are the major kinds of motions that are called upon here. Different motions have different purposes, naturally, as you can see, but they're called upon to make sure that functioning is proper, and while the entire parliament is functioning, every other thing is also taken care of, just to make sure of that this is done. Okay. Yeah. Shall we move forward? This was our motions. Yeah. Then we have another thing, that is Consolidated Fund of India. Consolidated fund, that includes the money coming from taxes, the money coming from fees and fine, etc. Okay. All this money goes into, this is where the salary of all the government officials is charged upon. Salary is charged upon. Okay. Then there is contingency fund. Contingency fund is under the control of president per se, but actually the finance commission handles it. The finance official, not commission, the financial official handles this, and president will take a control that contingency is an emergency fund. Okay, contingency is an emergency fund where in case of emergency, president will allow to take out some money from this contingency fund and use it like there's flood, drought, okay, war, anything that you could not have anticipated before, that is done here, right? Anything that you could not have anticipated before, that if that happens, that will be taken into account here. Okay, that is contingency fund for you. Okay, who controls that? President controls that. Who controls consolidated fund? Parliament has control over consolidated fund. Clear? Yes? Okay. Moving forward, interstate water disputes. Interstate water disputes is an important topic. Why? Because every other day this keeps happening in India, right? Water dispute, river dispute, that is very common. Interstate water dispute, you just need to understand who holds the power. Parliament. That's it. Who holds the power? Parliament has absolute power to create interstate water lines, to handle interstate water disputes, quarrels. All this can be done by the Parliament. Who does that? Parliament does that. Is that clear? In terms of what? Interstate water disputes, like river water distribution is there, right? Yeah. So if we are to do that, if we are to handle interstate water disputes, who will come forward? Parliament will come forward. Very simple. Parliament will come forward. That's all you need to know. That's it, right? We have multiple issues, like in Odisha, we have issue, Odisha, Chhattisgarh, right? Wherever water sharing is happening, we have issues everywhere. Who comes up? Who comes up? Parliament comes up. That's it. Who comes up? Parliament comes up. What is the mechanism? River Board Act is there, 1956. We have a River Board Act, 1956. And from there, the issue is taken up. This establishes the board to set up interstate river valleys. Interstate Disputes Act is there of 1956. Center will come up with a tribunal. Okay, Parliament or the center will come up with a tribunal to make sure the water distribution is done fairly. That's it. Yes? Yeah. Supreme Court shall not question the award. This is important. Supreme Court shall not question the award given by Parliament. Who is empowered here? Parliament is empowered here rather than Supreme Court. Okay. Yeah. Interstate Water Dispute Act. Another prelims question for you. Interstate Water Dispute Act. Who established that? 1956, the Interstate Water Dispute Act was established. This was established on the recommendation of Sarkaria Commission. On the recommendation of Sarkaria Commission. Another thing that you need to remember for prelims. Parliament has the power. Supreme Court cannot question the award. Commission was established. Act was established on the recommendation of Sarkaria Commission. Yes? Yeah. 1 year time frame, 3 year time frame, different time frames for different decisions. Okay? Yeah. Is that clear? Yes. These are interstate water disputes, the legal framework that we have, the kind of powers that we have given, right? Yeah. We have very many Kaveri, Krishna, Ravi, Vamsdhara, Narmada, Tapi, all these rivers crossing through different states have many disputes. So naturally, we need this disputes power. Yeah. Exactly. Is that clear? Yeah. Next is Attorney General of India. Attorney General of India. Let's take a look at the picture. Tell me, do you know the person? Do you know the person? Do you recognize the person? Try to guess a name. Try to guess a name. Give me a name. Come on. Give me a name. No? No? See, there's a hint. There's a hint. Try to capture the hint. I've come up with the hint this time. I'm not leaving you alone. I've come up with the hint. Yeah? Now do you get that? Ah, Venkat. Okay. Very nice. Very nice. Very nice. So, Attorney General of India. Talking about Attorney General of India. Who is Attorney General of India? Yeah. The Attorney General of India, basically, you can call them Constitution of India, has established by as the highest law officer. What do we say? They are the highest law officer of India. Okay, like administration has chief secretary, police commissioner has the commissioner, of course, and you know, every position has the highest authority, like president is there, Supreme Court is there. So likewise in law, Attorney General. In law, Attorney General, right? Constitutional body, it is a constitutional body, constitutional position. Okay, Constitution mentions that they are also chief legal advisor, right? They are the legal advisor and they are a part of Union Executive, and that's why you will see that they are allowed to hear the proceedings of Parliament, take part in the proceedings of Parliament, Supreme Court, everywhere they can go, right? Yeah, they are not a member of the cabinet, but a separate, you can consider them as a you know, separate entity, not a member of cabinet. Law minister is there separately, so they're not a member of cabinet. Please remember that they're not a member of the cabinet. Clear? Yeah, they are appointed as a judge, right? There is no fixed tenure given. No fixed tenure is given in the Constitution. They go by as it is. There is no procedure or ground for removal as well. That is why the position is favorite for UPSC. No position as and ground for removal either. Nothing is given. Okay. Yeah. No information has been given whatsoever for removal also. Nothing, just during the pleasure of president, that's all. During the pleasure of president, that is all that is given. Nothing else is known about the position, like how it is happening, why there no remuneration is fixed, right? Whatever it is, president will decide. Right? Yeah. They have the right to speak in the House of Parliament. Just remember that. They can take part in proceedings, speak in the House of Parliament. Okay. They also have the right of audience. Where can they have the right of audience? Over any court, in all the courts. Okay. In all the courts of India, territory, in the entire territory, wherever they are, they have privileges and immunities as well. Privileges and immunities similar to Member of Parliament. Similar to Member of Parliament, an MP. Okay? Yeah, that is Attorney General of India for you. Now, remember, this does not mean that they are a full-time council. They are not a full-time council of government. Okay. Generally, people confuse them as a full-time council of government. They're not a full-time council of the government. They don't fall under government servants. So, they're not debarred for private legal practice also. Not debarred from private legal practice. They don't come under government service, right? In case of AGI, we've seen that there are different positions. Here, yeah, that is AGI for you. That was our legislature. In terms of Parliament, we have seen legislature. then we'll come to executive. Yeah, moving on to executive, shall we? Yes. Okay. Moving on to executive. Executive has nothing much. Council of Ministers. Council of Ministers. What is Council of Ministers? You know that, right? What is Council of Ministers? There's a council framed of ministers to aid and advise PM. They come with collective responsibility. The only thing you need to know is there is a collective responsibility that if PM resigns, the entire council goes. But it is not equivalently, working in a vice versa way, right? Because if one minister resigns, council still runs. Okay. PM resigns, entire council goes, but any other minister resigns, then council keeps running. It is not collective responsibility in that manner, but still in terms of PM, it is what? Collective responsibility. You understand that? Yes? Yeah. So Article 74 of the Constitution talks about Council of Ministers, that there should be a Council of Ministers to aid and advise Prime Minister. That will also have Cabinet Ministers. That will also have Cabinet Ministers. Yes? Yeah. Ministers of State, Deputy Ministers, everybody will be included here. Deputy Ministers are also there. Okay. Yeah. All of them are here. We know, basic Council of Ministers. The total strength, total number of this, just one condition, just remember that. Total number should not exceed 15%. Should not exceed 15% of total strength of Lok Sabha. Total strength of Lok Sabha. That's all. That's all. The very basic condition that UPSC asks repeatedly is that 15% condition. The 15% condition, that it should not exceed 15%. That's all. Yes? Yes. Why this was added by 91st Amendment 2003. 91st Amendment 2003. That's how it was added. You understand that? Collective responsibility and individual responsibility. Is that clear? Yes? Yeah. That is Council of Ministers for you. Coming on to Schedule 10, Anti-Defection. Schedule 10, Anti-Defection. What is anti-defection? It is recently in news. Yes, because of Raghav Chadha and all the whole thing. You remember that scenario, Raghav Chadha with 7 ministers going, joining BJP and anti-defection coming to news. Do you remember that? Yes? Yeah. So this is very important for us. Do you agree? Anti-defection has been in news consistently and you need to know about that as well. Okay. So very simple thing in simple terms. 10th schedule, anti-defection. What are the grounds for disqualification? What are the grounds given here for disqualification? What is it that? There was a concept of Aya Ram, Gaya Ram. Do you remember that? Right? If you get selected, I am going like, oh, I am standing from A party, everybody votes for me for A party. I win and then I jump off to B party. Who keeps the win then? Do I keep the win because it was my face, or does the party keep the win because it was party's legacy, party's identity? Who keeps the win? Who keeps the seat? That became a question. So we came up with anti-defection, right? There were ministers who were just jumping here and there, right? To avoid that, we came up with this, that if you switch parties for personal gain, this is like switching for personal gain. What are the grounds for disqualification? Just remember these grounds, that's all. Voluntary resignation, obviously a ground because you're going. Okay. Voluntary resignation is a ground for disqualification. What is the other ground? voluntary resignation. Apart from that, voting against party whip. Voting against party whip. Now, whip is the monitor. Who dares go against monitors? Tell me. In the class also we don't do that. Independent members joining party after election. Independent members joining party after election. Okay. Till elections you were independent. The moment you get a seat, you are bought by other parties who require your seat and you are gone. Nominated members joining party after 6 months. Nominated members joining party after 6 months. The nominated ones also get new ideas sitting there. Okay, let's join the party. Yes, let's become a part of that. Let's play the ground. Let's become a member. Become member. There are rules, right? After 6 months, no, you cannot do that. Clear? Yeah. Who decides? The decision lies in the hands of presiding officer, that is speaker. Okay. Whoever is the presiding officer of the house, and they will decide regarding the disqualification, speaker or chairman. Okay. Speaker's decision is subject to judicial review. Clear? It is subject to judicial review. Decision is subject to judicial review. Please remember that. This is very important for your prelims. It is subject to judicial review. Is that clear? Yes, yes, yes. Please tell me that is clear. Please remember that. Please remember that. Yeah? Yeah. 91st Amendment came. 91st Amendment came 2003 and said that 1/3 of the party can live and cause a split. 1/3 can leave and cause a split, strengthening the removal. Exception is there, 1/3 split, limiting the size so that if 1/3 of the party goes, that's fine. Yeah. Yeah. Now, another thing that Supreme Court has said recently Supreme Court has said that as of 2026, they've said that speaker must decide within reasonable time, must decide the question of disqualification within reasonable time. Earlier, there was no time frame given. Constitution does not give a time frame within which speaker has to decide. So, Supreme Court has come up in 2026 with the decision that speaker must decide on disqualification within reasonable amount of time. Yeah, within reasonable amount of time, that you take your time that is needed for inquiry, discussion and everything. But after that, like 3 weeks something was set in recent cases. So that is just an example. 3 weeks was set recently, but it is not fixed. You can decide. Yes, you can decide. Here? Yes. This subjection to judicial review, remember this subjection to judicial review, this was done in a case. This was done in a case. Remember the name of case? Kihoto Holohan. Kihoto Holohan case. Okay. Yeah. Clear? Yeah. This is anti-defection for you. This is anti-defection for you. Is that clear? Done? Very nice. Moving on to local bodies. Moving on to local bodies. Nothing much to do here. Panchayat, 73rd Constitutional Amendment. That was Panchayat for you. Okay. That was Panchayat for you. Establishing Panchayat and municipalities. Determining Article 40 of DPSPs, Article 40, fulfilling Article 40 of DPSPs. We've established panchayats, 3-tier panchayats have been established. Okay, panchayats are in news, but more than panchayat, khap panchayats are in news. So you make sure to pay attention to that. Okay, khap panchayats are in news. Okay, you pay attention to that are not legal or statutory bodies, that are self-declared bodies. But here we have 3, like Gram Sabha is generally asked the question, all the eligible voters are a member of Gram Sabha. This is generally asked. Another thing that is asked is regarding their elections. Okay. what is asked is that after it has been dissolved, right? Let's say dissolved before tenure. A panchayat has been dissolved before tenure and we have to conduct re-elections within 6 months. Yes, re-elections should happen within 6 months. So let's say the tenure was 5 years and panchayat got resolved in 3 years. Okay. So now the other panchayat that will be framed right here will only work 2 years. The remaining 2 years, they will only work for remaining 2 years. It is only in case of local bodies that elections are conducted for remaining time period. As long as it is more than 6 months, because 6 months is anyway given the time for election. So as long as it is more than 6 months, the elections will be conducted for the remaining time period. That is a very important aspect of local bodies. Please remember that. Okay, please remember that in terms of local panchayat. Can you do that? Yes? Yeah. So we came up with 73rd Amendment and established this. When did we do that? 1992. We established Panchayati Raj institutions in India. We had multiple committees, Balwant Rai Mehta Committee. Yeah, Balwant Rai Mehta Committee, Ashok Committee. Okay. We also had GVK Rao Committee. GVK Rao Committee, right? These all committees came forward and finally gave their suggestions regarding their reservation for women, 1/3 reservation. Some have done 50% reservation, right? This is also there. And apart from that, what are we doing? Local demands are being catered here. We have constituted State Finance Commission and State Election Commission to cater to the appointment and financial needs of these bodies. Is that clear? Yeah. Another thing that you need to know is compulsory provision. Another thing that UPSC asks is, there are two kinds of provisions that have been set up for Panchayati Raj. There are compulsory provisions and for some it is not compulsory. Yeah. Organizing Gram Sabha is compulsory. Okay. Organizing Gram Sabha is compulsory. And apart from that, we have direct elections, that is also compulsory. Direct elections need to be held. 3-tier system is not that structural, but still you have to create 3-tier panchayat system in panchayats, but it is not necessary in municipalities. Okay, it is not necessary in municipalities, but minimum age 21, that cannot be changed. Minimum age to be 21. Like that, we have many compulsory provisions, yeah, and some are voluntary provisions. Both of them are here. Both of them are here. Voluntary provisions like voting rights, devolution of the powers, all these can be done. Clear? Yeah. Same for municipalities. 74th Amendment, 1992. 74th Amendment, they've been set up in 1992 and the powers have been extended. And now from the powers extended here, we come up with urban local bodies, right? We come up with urban local bodies that have the term of 5 years, urban local bodies with the term of 5 years, same procedure, elections for the remaining time, 3 levels. What are the 3 levels? Nagar Panchayat, right? You will have Nagar Panchayat, first of all, Panchayat level only, Nagar Panchayat, Municipal Council, and then Municipal Corporation. Municipal Council and then Municipal Corporation, based on population, of course. This is done based on population. Okay. Yeah. For 5 years they will be here. State Election Commission and all same, they will work in the same manner for them. And planning will be done by District Planning Committee and Metropolitan Planning Committee. Here? Yes, that is it. That is your municipality. Like most of the powers are here, same. Okay. Moving on to judiciary. In terms of judiciary, we'll see that The important thing is removal of judges. That has been constantly in news. And for removal of judges in terms of judiciary, we come up with impeachment process. Okay. Impeachment process. We need to understand the process of removal of judges, how impeachment works. Now, impeachment, removal of judges, if we are doing, we are going towards impeachment. Impeachment comes with two basic guidelines, that is proved misbehavior or incapacity. Okay. Come up with two structures, that is proved misbehavior and incapacity. These are the two reasons through which we can do this. Okay. Judicial impeachment, the word impeachment is here. And just remember, impeachment is not a word given in Constitution. Okay. For prelims, just remember that this is not a word given in Constitution. For impeachment, what we do is, what we are doing is, first of all, initiate it. We will come up with 50 members support. 50 members support for impeachment. Okay. After that, it will be introduced. Okay. And in terms of Rajya Sabha, we will have 100 members. Right. In terms of Lok Sabha, we will have 50 members. It can be initiated in either house. Right. Yeah. Then Speaker or Chairman will approve it. Speaker or Chairman will approve. Only then the process will start. Okay. Only then the process will start. If Speaker approves, there will be an inquiry committee set up. An inquiry committee will be set up. Through this inquiry committee, an inquiry committee will be set up, and through this inquiry committee, a 3-member committee, that is, okay, mainly a 3-member committee, can be changed as such. They will act as fact-finding body. Okay, they will inquire whether there has been misbehavior or not, or whether there is incapacity or not. Then the report would be put forward and the houses will vote. Report plus vote. Okay, they will vote. We need special majority in both houses. Okay, then we need special majority. What kind of majority do we need? Both houses need special majority in the same session. That means it should be passed by absolute majority and then 2/3 majority. Okay. Yeah. Then comes President's approval. Then comes President's approval. Now, does President have any power here? Does President have any power here? Yes. Yeah. They can be removed by only the order of President, but President doesn't have a power to say no here. They don't have the power to say no. Right? And no judge has been impeached so far. No judge impeached so far. Okay. Now tell me the recent case. Yashwant Verma. Do you remember the case of Yashwant Verma? Was there an impeachment? Was there an impeachment? Yes. Yeah, that's when it changes. That's when it changes. Okay. Yeah. Remember that. That's where it changes. Yeah. Moving on. Same process for removal of high courts as well. Same process for removal of high courts as well. Impeachment is done, governor plays a role, then president comes, same process. Okay. Now we are moving on to important bodies or councils or organizations for India. That is, first of all, we'll be talking about Election Commission. Okay. First of all, we'll be talking about Election Commission. Shall we do that? Yes. Okay. Election Commission, there is CEC plus 2 other ECs. Okay, this is the composition. CEC and 2 other bodies. Is that so? Yeah. Now, Election Commission, the Election Commission or Chief Election Commissioner, as we say, the most important thing here for you to note regarding prelims is that their voting capacities. Okay. Number 1 is their voting capacities. Okay. How is it so? They don't have, CEC doesn't have a decisive vote. They go with majority. Okay, they go with majority. Like if there are 3 of them, 2 say yes, 1 says no, it will be yes, regardless of what CEC is saying. So naturally their positions are not like CEC is the head and then 2 members. No, they have equivalent position, equivalent rights, everything. Okay, just the salary is a bit different, that's all. Okay, but other than that, same. President does the appointments. They stay till the pleasure of president. Same process, right? Same process. President will do that. There will be a selection committee. There will be a selection committee that will come forward for this. That's it. That's it. Okay. Yeah. Term 6 or 65. Term is 6 or 65. That's all you need to know. That's all you need to know. Removal or resignation, naturally they can be removed in the same manner as judge and resign to president. Resigning to president. Clear? Yeah. UPSC. Do we know about UPSC? Yes, Union Public Service Commission. What do we know about UPSC? What do we know about UPSC? Yeah, Union Public Service Commission that conducts exams and hires administrators. Yes. Yes, that is UPSC for you. That is UPSC for you. What do you need to know about UPSC? For UPSC? Yes. Yeah, public service commissions are there. We have UPSC as well as we have state PCS as well. Yeah, right? Central recruiting agencies. There's an independent body. Just remember that there is an independent body, constitutional body. Under Article 312, they constitute services, right? Yes, that's it. Okay. Yes. Composition, president will appoint. 665. President will appoint, that will remain same. Okay. Yeah. Removal, same by president. Okay, everybody will be removed by president. Okay. Salaries coming from Consolidated Fund of India. That's it. Removal by. Okay, resignation also to president, naturally they can be removed by president. Conditions, same, insolvent, office of duty, something they have done, or they are not fit anymore to carry out the work. That's all. Okay. Yeah. Next thing we have to discuss is GST Council. The major thing that you need to know about GST Council is this: the composition. Who's the chairperson? Union Finance Minister, elected from members of the council, vice chairperson, then members representing central government, UT, state government, union ministers in charge of revenue, finance ministers from all 28 states will come together, and other relevant union ministers. Prime Minister can appoint them as required. Finance ministers or other ministers from legislatures like Delhi, Puducherry can also come. This is a clear combination of center and state. Yes, a clear combination of center and state, a very good example of federalism. Yeah, this is the major thing that you need to know. Other than that, the whole taxation and everything that has been asked multiple times now. Okay. Yeah. Coming on to Schedule 5 and 6. Schedule 5 and 6 that represent the scheduled areas and scheduled tribes. Okay. All the scheduled areas except AM/TM come under Schedule 5. Okay. except AMTM. What is AMTM for you? Assam, Meghalaya, Tripura and Mizoram. Yeah, Assam, Meghalaya, Tripura and Mizoram. This will have AMTM scheduled areas. Remember that. President has a lot of power here. President has a lot of power here. Why? Any law that is being framed does not necessarily apply on them. President will decide whether any law will go to them or not. Okay. Yeah. So this consists of only 10 states as of now, because other states don't have scheduled areas, and this consists of AMTM. Okay. Assam, Meghalaya, Tripura and Mizoram. Is that clear? Yeah. In the fifth schedule, first of all, governor has power. Then the power will come to president if governor needs it. Okay. Governor has the power. They will set up tribes advisory council for their welfare. Tribal advisory councils will be conducted here, and that way they will be dealt. Okay. And in terms of schedule 6, we will see that specifically covering the tribal areas of Assam, Meghalaya, Tripura and Mizoram, their autonomous district councils run. They have autonomous district councils instead of panchayats. They don't have panchayats, okay? They don't have panchayati raj institutions. Is that clear? They don't have panchayati raj institutions. These autonomous district councils are what create their power, and they create the power and they spread, awareness and create village councils, all these things, okay? Yeah. So this is to safeguard the land, culture, etc. of the scheduled areas of rest of the states, and for the scheduled areas of AMTM, that is Assam, Meghalaya, Tripura and Mizoram. That is specifically schedule 5 and schedule 6 for you. You understand the difference? Yes? You understand the difference? Very nice. These were the major topics. The last thing we need to discuss is a few amendments, some amendments that are repeatedly asked in UPSC. Only those amendments we will discuss, and that then we'll be done with the session. Okay? Yes? Okay. The last thing, come on, show me some energy. Last thing that we are discussing is important constitutional amendments. Let's talk about them one by one. First of all, the first amendment that is laying the foundation, ninth schedule that is called the black hole of constitution. Black hole of constitution. Yes, it was called black hole of constitution up until there was no judicial review. Now there is the judicial review, so it is not a black hole anymore. Yes, they added 3 more grounds for restriction of freedom of speech and expression also. And with that, they empowered states to make special provision for socially and educationally backward classes. Okay. 7th amendment came, we did state reorganization, and on the basis of SRC, state reorganization commissions. Then we had a class removal, that is, we abolished the existing classification part A, part B, part C, part D states that we had. Then high courts, they established common high court for 2 or more states. This provision was added by 7th amendment 1956. Is that clear? Yes. Then came 24th amendment. 24th amendment, the first thing 24th amendment brought down was parliamentary supremacy. They affirmed that the power of parliament to amend any part of the constitution, even fundamental rights, they can amend. Parliament is supreme in amending the constitution, but this will later be reversed, right? Because we will come up with basic structure. We don't have basic structure yet. We will come up with that after 1973, but until then they're saying that parliament can amend anything. Okay. Then presidential assent, they said that president has to give assent to constitutional amendment bill if it is passed by both houses. Before 24th amendment, president actually had the power to say no to the amendment bill. Now, no. Okay. Now, president cannot decline it. 52nd amendment, 10th schedule, anti-defection, we just discussed this. Okay. 61st amendment, voting right, voting age from 21 to 18. Because of this, CEC was given 2 other CEC members. Earlier, India only had one CEC, that was Election Commission. Later on, because of this amendment, we added 2 more ECs because responsibility increased. 73rd amendment, we just discussed Panchayati Raj institutions. 74th, urban local governance also we just discussed. 86th amendment, we discussed Article 21A, right to education, 6 to 14, remember that? In DPSPs, we made a change, 0 to 6. Fundamental duties were also changed because of this. Yes. Then we had 97th Amendment, fundamental rights, added cooperative societies, DPSPs 43B, inserted cooperative societies there as well, and new part 9B for cooperative societies was added. So it is completely related to cooperative societies. After the success of Amul as a cooperative society, we've been paying a lot of attention. Yeah. 100th Amendment, land boundary with Bangladesh. We gave land, we took land. Now remember that to take land, we don't need constitutional amendment. To give land, we need constitutional amendment, right? For this, you should read Article 1 to 4. Article 1 to 4, this will be more clear there. Okay? Yeah. So we had certain disputes with Bangladesh. We still have disputes. Despite this, we still have disputes. Solved nothing. But still, we tried to solve it by land exchange. Lastly, 106th Amendment Act, Nari Shakti Vandana. Milestone, 33% seats reserved. This is the major issue today. Major issue because we are not able to apply this. The implementation of this would only happen around 2037. That's how long it will take if we go at current pace. That's why the whole new census, new delimitation, everything is, raised in a question. In current, you must have seen that. And this is 106th Amendment for you. And that was our session. That was our session regarding polity and important topics of polity. I hope you had a good coverage. Please revise the topics that were listed here because they have been repeated consistently in the news as well as in the UPSC. In the past 10 years, we have nitpicked a few topics for you. And these were the topics. Yes, I hope you had a good revision. Actually, throughout this, we've done large-scale revision of entire polity, have we not? Yeah. So this was it. And thank you so much for joining in. I hope you enjoyed the session. All the best for your UPSC Prelims 2026. Take care. Thank you. Bye-bye.
For more informative content, like, share and subscribe. And do not forget to press the bell icon to get the notifications.